I know. I was
We are on the record.
What's on it?
Item number 3, everybody wants this talk.
All right, I'd like to call the September 6th meeting to order, please.
This is the meeting of the Sunshine Ordinance Task Force, meeting of September 6, 2017. Time is 4:03 p.m. On the call of the roll. Member Eldon. Eldon present. Member Josh Wolf. Josh Wolf's absent. He should be here shortly. Member Copra. Copra absent. Member Tesfa.
Present.
Tesfa present. Member Moss.
Present.
Moss present. Member Kanata.
Present.
Kanata present. Member Fisher.
I am here.
Fisher present. Member Hinsey.
Present.
Hinsey present. Vice Chair Hyland.
Present.
Hyland present. Chair Wolf. Wolf absent. And I believe that Vice Chair Hyland will be acting as chair at today's meeting.
Thank you.
There are no agenda changes that I know of at this time.
Okay. Call next item.
Next on the agenda, item number 2, approval of minutes from the Sunshine Ordinance Task Force August 2nd, 2017 meeting.
I'd like to make a motion to approve the minutes.
I'll second.
Any comment on that? Any public comment on approval of minutes? Seeing none, if we can take that by acclamation.
That motion is passed with members Wolf, Josh Wolf, and members Chris Hyland being absent at this time.
No, Bruce Wolf.
Both Wolves are absent at this time.
Yeah.
The wolf pack is absent at this time.
All right.
Next on the agenda, item number 3, file number 17093, hearing, review of Sunshine Ordinance Task Force bylaws and complaints procedures, hearing procedures, testimony, and public comment.
Who was the subcommittee? Was it you, Frank?
Yeah.
Okay, if you can give us a quick summary of this item.
Yeah, so at the Compliance and Amendments Committee meeting, the discussion was begun regarding members of the public giving testimony either for the complainant or the respondent, and then not allowing to give public comment on the process after a motion was made. There was a discussion. There weren't many people here then. I see there's a lot of people here now. And it was basically just discussed, and people gave their viewpoints on the issues. And some issues were brought up in the fact that if a person giving testimony then were to be able to do public comment on the process after the motion is made, to limit that to comments on the motion, and how do you govern all of that? But that was the brunt of the discussion.
Okay, thank you. And if you look at your packets, what we're discussing is our current policies, item 10.6, which is how we treat public comment at this point. And that's really what we're deciding on, whether we continue to do that or make changes to that based on some of the testimony we hear today. We also have on the line a First Amendment expert, David Snyder, who we've invited to talk with us a little bit today and illuminate the task force. We'll then have some discussion. We'll take some public comment. And members of the public, if you have any questions as to what was discussed or even questions for David, please relay those through us, and we'll present them to Mr. Snyder, as we see fit. So having said that, why don't we give the floor to Mr. Snyder.
Ms. Snyder, can you hear us at this time?
Yes, I can. And thank you for the invitation. It's been a little while since I was there. I served on the task force for a couple of years some time ago, and I'm happy to help to the extent I can, both the task force and members of the public, to understand what I understand Section 10 of the bylaws do now, and what leeway or wiggle room there is for changes in the procedure. As I understand it now, the procedure that the bylaws set forth provides for the complainant to be able to present facts and evidence, then the respondent to present facts and evidence, and then the complaint then goes to the task force for discussion and any questions to the party, and then respondent and complainant have an opportunity to present clarification or rebuttal. And then the complaint goes to the task force for motion and deliberation. And then the issue that I understand to be really at issue here today is the following step, which is public comment, general public comment. And the bylaws currently provide that the complainant and the respondent and any of their witnesses are to be excluded from public comment, from general public comment. And so I guess I'll start by just saying what I think about the procedures as they are. I don't think there's anything in the Brown Act or any other authorities that I know of that specifically govern this type of scenario, but I think the relevant question is, do the bylaws as they stand now give everybody a fair opportunity to make argument, to present facts, and then to provide any rebuttal? And does the current procedure allow adequate opportunity for the public to be heard? I think it's important that all three, respondents, complainants, and any of their witnesses, and the public, be given full and fair opportunity to address the issue before the task force. And I think the bylaws as they stand now do that. I think that the complainant and the respondent and any other witnesses have two separate opportunities to address the issue before the task force. That's in their initial presentation and then in their rebuttal if they choose to rebut. And the public also, of course, has an opportunity to speak. And so is it okay to exclude the respondent, complainant, and any of their witnesses from the general public comment? And I think that it is for a couple of reasons. First, the bylaws as they stand now adequately, they provide the complainant and the respondent to make their argument and to rebut and to present any witnesses that they want to present. Then for the task force to take the issue up for a motion after that, I think is proper. Both parties have been given full and fair opportunity to say what they want to say. And then the public, of course, needs to weigh in, but I think it's proper, or at least not improper, to exclude the complainant and the respondent from the general public comment because they've sort of been given they've been given opportunity to say their piece. And the task force has an obligation to move as expeditiously as possible while at the same time giving everybody fair and full opportunity. And so I think it's legitimate for the task force to say that at the general public comment, the respondent, the complainant, and any of their witnesses can't come up again and sort of re-argue their case. And I think that's valid and it's legitimate, and it tracks with general procedures in court for briefing or for oral argument. Everybody gets an opportunity to make an argument. They get an opportunity to hear what the other side's argument is, and they get an opportunity to rebut. So a third, allowing the respondent and the complainant to come in at public comment provides a sort of third bite at the apple, and I don't think that's required or necessary. So I think, in conclusion, as to the sort of first aspect of this discussion, I think the bylaws as they stand now are fine. I think they provide full and fair opportunity to everybody that needs to have it. That said, I think that if the task force wished to, it could provide opportunity to the complainant and the respondent and any of their witnesses to speak at public comment. I think what the task force would need to take into account is that could substantially increase the time of the meeting. And I think the task force would have to provide both parties and probably also any of their witnesses an opportunity to address the task force at the public comment time. In other words, it would be improper, I think, to allow just the complainant or just the respondent to come up and talk during public comment. I think the task force would have to allow both to do that. But as I said earlier, I don't think the task force needs to do that. And I think one thing the task force should take into consideration is that allowing that opportunity would increase the amount of time that the meeting ran, and I think would do so unnecessarily. One possibility that the task force might want to keep in mind is that I think it is within the discretion of the task force to allow, in certain circumstances, the complainant and the respondent to come forward during the public comment section. But again, if they did that, if the task force decided to do that, it would need to provide that opportunity to both sides. And it would also, I think it would be, it's okay for the task force to do that at its discretion. The task force probably wants to take into account that it might want to have some rules or guidelines about when it does that, because I think the public would perhaps rightly see perceive inequities in when the task force decides to allow respondents and complainants to come forward and when they don't. So I think that the way the rules are set up now is acceptable, and I don't think they cause any problems. I think the task force also has the discretion to tweak them as the task force wishes.
Okay, that's very informative. Thank you, Mr. Snyder. Can you stay with us as we talk a little bit about this?
Yeah.
Okay.
Sure.
Member Tesfaye?
I have a specific question for Mr. Snyder. I guess I'll give you a scenario. We were talking about parties being able to state their case, give the facts of their case, and whatever legal analysis they're giving for their case. But we offer public comment on specific motions that are made by the task force members, and we have that public comment period for all of those motions. Can you speak specifically to giving parties the opportunity to respond to a motion that is proposed by a member of the task force? Because, right now as it sits, we would only be giving the parties and their witnesses an opportunity to open their case and give a rebuttal, but not to respond to a specific motion that has been proposed by a member of the task force. We would only be allowing for regular public comment of that motion.
You're talking about a motion that addresses the issue that the respondent or the complainant has testified about, not some other motion.
Correct, though even if an issue has not been raised by the petitioner, by the complainant, a task force member could raise a motion on that issue if they have identified on their own that there's been a violation, for example.
Yeah. So the motions, as I recall from my time on the task force, the motions most typically are a motion to find a violation or perhaps a motion to find no violation. Are there other types? Well, let me stop there in a way. If the motion is to find a violation or to not find a violation, and that's all the motion consists of. There's nothing really further that the task force has. There's nothing the task force has proposed to do that would go beyond the issues that have already been addressed by the respondent and the complainant. If the motion did something more or different than just proposing to find a violation or to find no violation, then I could see the argument being made, well, shouldn't the complainant and the respondent have a chance to address some tweak, in the motion, a motion that's not just binary, find a violation or not find a violation. I can see and I can respect where that argument's coming from, but I go back to my earlier thought and conclusion that providing the respondent and the complainant inability to make their argument to the task force, to address any arguments that the opposing party has made to the task force is sufficient. I don't see a need, and I don't know of any requirement under law that the parties have an opportunity to address the specific motion in front of them. If they want to re-argue the motion, or they think that the task force has done something improper with their motion, there are procedures in the bylaws for asking the task force to reconsider. And I think if the task force opens up public comment to respondents or complainants or their witnesses, what they would, in essence, in some or maybe many cases, be doing is providing an opportunity for sort of re-arguing the motion, or arguing that what the task force wants to do is, or what the motion proposes to do is improper and should be decided some other way. And that's really a reconsideration issue, which, as I said before, the bylaws provide a separate procedure for. Does that address your question?
Partially. I mean, there are other motions that we take up, for example, to table a matter or move it to a different date, for example, if a respondent from a city department fails to show up or something like that. So there are different types of motions that we take up that aren't just part of the binary violation or no violation. And I'm not sure when a party would be able to speak to that issue if we don't allow them, maybe not to participate in public comment, but not to have a separate time for them to respond to the proposal.
Yeah.
So.
Well, if the motion is to table it for whatever reason, well, let me address it this way. The key question is: do the parties have an opportunity to make their case on the merits? Have they had the opportunity to present the evidence and make any argument that they want to make as to the alleged violation? And I think unless there's a motion in front of the task force that somehow substantively or changes the substantive, let me put it this way, requires some substantive response, in other words, legal argument or presentation of facts, I don't see why the respondent or the complainant would have to have the opportunity to address the motion in public comment. If it's a purely procedural matter, such as tabling the issue, there's no substantive issue to be addressed by the respondent or the complainant. There's no legal argument or presentation of facts that the respondent or complainant could make that would alter the course of the motion or change the nature of the motion.
Member Tesfaye? Anything else? Yeah. Any other members of the task force? Any questions for Mr. Snyder? Just to, kind of paint the bigger picture for most of the task force, this was a system that we adopted at this task force. It's not necessarily, I think there might be one or two other bodies that uses, I believe the Ethics Commission also uses this process. It's been 20 years we've been using it. We're always open to improving our process. So I think it's healthy to have this discussion. But I think what Mr. Snyder is saying is that, maybe 90 or 95% of the merits is pretty much captured by the time we get to, public comment. And I think both parties will know which way the task force is leaning. It will help them, they'll be able to, do their rebuttals. The motions are typically fall along what the item listed. We might add a few, pieces like 6721E or other things we might add on out of the chapter. But I think most of the work has already been done at that point. I will point out, though, looking at Section 10, 6 is public comment, 7 is vote by the task force brackets, public comment at the discretion of the chair on each motion, and or new motion if vote fails or motions change. In practice, sometimes we've been rolling that up into one public comment after the motion, when it's maybe a fairly black and white kind of case. So that was interesting to see that there's two actual separate opportunities for public comment there. If there's no other discussion at this point, I'd like to open it up for public comment because we have quite a lot of people here, and I'd like to hear what the public has to say on this. Victor.
Oh.
I'm Bob Planthold. I'm a former long-term Sunshine Task Force member and former officer. I'm the person who raised this issue. I'm sorry. Am I not coming through? I don't know what the chair's sign
I'm
language.
just saying, can you talk more into the mic?
I'm trying to, as close
okay.
as.
Okay, got it. Thank you.
I'm a former longtime member of the task force and former officer. I'm the one who raised this issue. The discussion so far is not responding to the way I framed it initially. I did not talk about the complainant or respondent. I simply said the witnesses. And I based that witnesses ought to be able to make comment on a motion from other experience I had on non-complaint matters before the task force, where I would make a comment on the motion that maybe, hey, your packet indicates a certain report, you didn't address that report, or some of you talked this way in your questions and answers, but it doesn't show up in the way the motion is phrased. So I would use that public comment to say, I think the motion's missing something on non-complaint matters, and it struck me that we ought to be able to also call attention to a motion on a complaint to say you're missing something from your discussion from the report. And it was simply that, to be a comment on the process where the motion might be not as good as it should be or somewhat missing something. And again, that would be the chair would have to caution and make sure people didn't try to re-argue the case a third time. I understand. But while the rules call for a discretion of the voice of the chair, what if the chair is just not interested because she or he wants to run through the meeting and get out of here? That's why I think it ought to be addressed in a more specific way to say on the motion itself as to, and you figured out process, completeness, accuracy, thoroughness. I think that ought to be considered as eligible for anybody, including a witness. That's all. Thank you.
Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. And I agree. I understand Mr. Planthold's argument. I unfortunately, for all the years I've been attending the commission, see it opening a real can of worms, which is I have gotten used to the procedure, and I do not make any comment for either party until it gets to general public comment, and that way I have the ability to address either issue or any of the issues that either party to the case have brought up. Unfortunately, I think once you say to somebody, okay, I can testify on someone's behalf, and then get a second chance to relitigate, which is, I think, what people are going to attempt to do. And it will be very, I think, abnormal for most people to not get up and segue into an argument as to why they feel, given the evidence they previously submitted, what the task force is doing is wrong. And how a chair would ever control that and say, okay, you're veering off into, unfair territory because you're now going into the argument and relitigating the case. I think that's an onus to put on a chair that is a bridge too far. It makes it too difficult. And these cases have a tendency to drag on pretty long at some points already without adding extra Durham and Strong to the issue.
Thank you. Everything okay, Mr. Snyder? Oh, is that you?
I cut off his mic, so.
Oh, okay. All right.
Is there any additional public comment?
You put his mic back on. Seeing no additional public comment, it's back with us to discuss. Mr. Snyder, did you hear both those commenters, those public commenters?
Yes, I did.
Okay. Would you have anything to respond to that public comment?
Yeah, I would just make the point that if you think of witness in the terms that a lawyer litigating a case thinks of a witness, it might help, I don't know, it might help clarify the issue somewhat. A witness is someone who's presenting evidence on behalf of or in support of a party. You know, a witness isn't somebody who makes legal argument. So I don't know how this plays out in practical terms, but in purely kind of legal terms, I would say that if what a member of the public wants to do is address something about the way the task force has approached the issue or highlight something that the task force missed, what that person really is doing is commenting as a member of the public, not as a witness. I think this dovetails with what Mr. Hart said. If what the member of the public wants to do is just comment generally about the procedure or about the complainant or the respondent or how one of those two parties address the issue, that's a public comment. You know, that's not really a witness. Does that mean that the task force, if someone gets up as a witness and starts talking and the task force ascertains that they're really not a witness, they're really a member of the public, and they should say, well, why don't you hold your comments till the end? I don't know. That's, you know, an issue for the task force to address. But I do think that Mr. Hart's concern about the case going on and on and on and allowing the parties and the witnesses to sort of continually re-argue the case is a real concern, and I think a legitimate concern. The task force obviously shouldn't be in the business of just blowing through issues without fairly considering them, but the task force does have the ability to structure its meetings in a way that everybody can be heard on a single day. You know, the task force has an obligation not just to the individual parties to an individual case, but to everybody that has an item before the task force that day, and so they have the obligation to move as efficiently as they can, while at the same time making sure that everybody is heard.
Thank you. Yeah, there's been many cases where respondent has delivered their piece, and I think the language we use is if there's any witnesses or people that would like to speak on behalf of the respondent, please stand up. And someone will stand up quite to the surprise of the respondent and deliver their 3 minutes, which in the end may not help their case. So I've seen that happen too. And I don't know if that's something we should tighten up on our end, and maybe have the respondent list the witnesses they would like to present, or whether they then become part of, become party or part of the team. I'm not a lawyer, so I don't know exactly how that would work, or whether we want to get into those semantics or not. But I appreciate Mr. Planthold bringing up the witness issue as opposed to just the general, because that did not come through too strongly in our in the notes we have here out of the subcommittee. I'd encourage the task force to discuss this a little bit more. I see Member Mass would like to say something.
Yeah. So during the committee where Member Kanata and I believe I don't believe you were.
I think I switched with Member Hines. Yeah. So I wasn't there for that one.
So some of the things to consider is that, under the Sunshine Ordinance during public comment, you're guaranteed uninterrupted, speech for a few minutes, which isn't the same for the, things that are said during the process. We tend to grant people uninterrupted speech, but it's not something that's mandated except beyond our rules. One of the things that I had suggested as we were discussing this as something for us to consider is that during the witness, our rules say that, provide I just want to make sure I'm saying this correctly, prevent facts or evidence, that we were to limit what the witnesses were able to say to, I witnessed this meeting, I know this happened, or, nothing that is opinion-based, but rather simply presenting like, I received the same copy of this document that was rejected for him, or I had the same experience with this department, but it would be at our discretion whether to interrupt and ask questions during that period, or, if they strayed off, to be able to cut them off without it being curtailing their rights for public comment. And then for everything else they wanted to say, about the motion, about opinions, because sometimes we might take public comment twice, 3 times, depending on how many motions we have. I mean, I've seen the chair bring it up several times, and it feels like if we have somebody comment once, we are disincentivizing for them to be giving witness information, because if they give that witness their testimony during the witness, they may lose 2 or 3 opportunities to public comment later. And I feel like that would be one solution to address it.
Yeah, fair enough. I actually wanted to ask Mr. Planthold, you were around at the beginning of this body, and I imagine you had you've worked with this process, maybe even had a hand in setting it up. Is there anything that's changed? What brings us up now? Is there any body of law that you can read to us that maybe should persuade us to make a change?
So this is. Can you put the mic on, please?
It's on.
Okay. This is Bob Planthold. There's no body of law. During the time I was, my term ended 2002, 15 years ago. Nobody came up with the type of analysis that I'm offering now. The experience that I'm basing this on is subsequent to my time on the task force, when I would come to talk about an item that I found worthwhile, or where I found I had information about a specific policy issue you were addressing. And so the concerns, the scenario I raised is subsequent to my time in the task force. During my time, there wasn't anybody coming up with the type of process analysis that I've passed to you now. I know of no body of law specific to this. I was just suggesting that when people are prevented from saying, hey, your motion is missing something, that can be figuratively causing a problem for down the line for the implementation of the motion, or for either or both parties to feel they were fairly responded to by the motion.
Thank you. So, I think what we should consider is, do we, carry on with the status quo as is, and we can have a vote to reaffirm that if we want to do that, or we can consider allowing witnesses specifically to be able to also make public comment on motions or new motions. I think on balance, there's, maybe a couple of witnesses per case, sometimes none. It might mean a few more minutes of work for us. Doesn't seem unreasonable. And there's certainly a reasonable argument on both sides. I'd just like to see where the task force is on this. And Mr. Snyder, if you have anything additional to add, I would welcome that also.
I don't at this time.
Okay. Members of the task force, any further discussion?
Well,
Member Kanata?
yeah, I think that if a person is acting as a witness, they're taking their time to come to a meeting because they're involved in the case that's going on, and I would think that they should have an opportunity to do general public comment. Now, regarding what Member Moss had said, I think it would depend on the chair and on the situation at the given time. If during the time that person is being a witness, they're giving their opinion or talking about process, to cut it off, or to ask the person to just provide facts about the case. But I think that the person should be allowed general public comment.
Okay. Yeah, we don't make it we try not to cut people off, even if they're off topic. We typically give them their 3 minutes and let them say their piece. Sometimes that's the more politic way to go. But Member Moss, any further thoughts on?
No, I don't think so. I mean, considering that we're fairly low on attendance today, I would probably think it not wise for us to make a decision on this without the chair here, at least.
I did talk to the chair about this, and it would be good to make a decision and then adopt that going forward tonight. So we do have to either reaffirm what we use, or add this witness piece and move on. That I think would be the expeditious way to move. There's an odd number of people here, so a vote will have a result. And Victor, what do we need for is this a administrative procedure or is this a substantive change? How does this register?
I do not believe this is purely administrative. I believe we need a quorum of the full task force. However, please note that any amendments to our bylaws need to be posted 14 days prior to adoption.
Okay.
So you can make the suggestion today, I could post it, and it could be adopted at our next meeting.
Okay. Or not adopted.
Yes.
Okay. All right. So that would essentially be, a continuance. Would someone like to propose a motion? See how it goes. Member Eldon, you look like you were.
I'll propose a motion that people providing witness testimony be allowed to participate in general public comment on the issues, on the motion.
I'll second that.
Okay. We have a motion on the floor. Any public comment on that motion? Seeing none. Call the roll.
On that motion, Member Tesfa.
No.
Tesfa, no. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
No.
Fisher, no. Member Hinsey.
Aye.
Hinsey, aye. Member Eldon. Eldon, no. Josh Wolf, absent. Chair Wolf, absent. Acting Chair Highland.
I was hoping it wouldn't come to this.
There's no quorum.
What's that?
It doesn't. It needs six ayes to pass.
Oh, okay. Well, I'll vote aye. That's where I was feeling this.
That's a vote of 4-3. The motion fails.
Okay. So I guess we'll continue as we have been
Yes.
on this
Thank you.
item. All right. Mr. Snyder, thank you very much for your insights. Appreciate you being here to help us.
Sure. Happy to help.
Okay. Thank you.
Thank you.
Next on the agenda, item number 4, file number 17044, complaint filed by Laura Clark against the Ethics Commission for allegedly violating Administrative Code Section 67.7D by acting or conducting discussion on an item not appearing on the posted agenda. This is regarding Ethics Commission April 24, 2017 meeting. And this was reviewed on June 20th, 2017 by the Education, Outreach, and Training Committee. The committee determined that the task force has jurisdiction and referred the matter to the task force without a recommendation.
And chair of that committee was?
That would be Josh Wolf. He's not here at this time.
Who else was there? Member Eldon and Member Fisher. Yes. Take a few seconds, and maybe one of you can give us a. Member Moss?
May I ask just a question before
Sure.
while they're looking that up?
Yeah.
So if I understand this complaint correctly, there is an allegation of willful failure, and since this is against the Ethics Commission and a willful failure is to be heard by the Ethics Commission, I'd assume that we would not send this to the Ethics Commission if such a finding was made. And I was wondering procedurally where this would go from here, because it would help frame how I consider this.
That's a good question.
Maybe DCA Cola might have an idea.
Is there a willful allegation in here?
The letter says it.
We'll get to you in a moment. Thank you.
I'll have to review that.
While that's being reviewed, can Member Eldon or Member Fisher give us a quick, or if it's too long, we can just dive right in. That's not a problem. Victor?
What I specifically remember is that we have to be very, very careful to compartmentalize the complaint, because I think we went way off into the weeds on what was the woman's name? Christine something. It was whether or not she was or had a conflict of interest or something. But that seemed like that was something tangential to Sunshine Ordinance. So I think we kept spinning around on this, and I kept coming back to, but what is the Sunshine Ordinance part of this?
Okay.
So I would caution us to go down that sunshine track and not end up on some other
Always good advice. Okay, thank you. Do we have both parties here? I recognize. Okay. Petitioner. Okay, 1 second. And we did find jurisdiction in this?
Oh, it's
Yeah.
San Francisco.
Okay. Victor, did you have something to add?
Yes, I can give you a brief description on the matter.
That'd be lovely.
There is an allegation that the Ethics Commission took an action on an item that was not listed on their agenda. The allegation was that the Ethics Commission had enough knew of this issue prior to publishing their agenda, and that they could have placed the item on the agenda. I believe the Ethics Commission stated that they did not know that this was an issue that could be placed on it, and the first time they became aware of the issue was at the time of the meeting, and they exercised provisions of the Sunshine Ordinance to take emergency action.
Thank you very much. Okay.
That's Victor something, Chris?
Hold on. If the Member Fisher? Go ahead.
Why don't you go first?
Yeah, and so, I think we heard this.
Can you speak into the mic?
We heard this a few months ago, as I recall, but the issue came down to we were trying to establish a timeline about when they might have known, and there was a SF Examiner column that seemed to say that Commissioner Kopp had heard about the matter beforehand, but it was hard to decipher because the article had come out after it had come out a couple weeks later, and so that was part of the basis of the claim, and it was really hard to untangle exactly who knew what when and was the article accurate. So we struggled to really nail down what the violation was.
The timeline and everything. Okay. All right.
My question to Victor was, you mentioned at the very end of that, and this was the part that I kept getting stuck on, was the emergency aspect. Were we ruling on this being an emergency or not? Because that's really not
brought
our
up during the
purview.
discussion, but I don't know which direction the committee was taking.
Okay, because that's a tough one for us. That's not really a sunshine.
I think we can probably unravel
There's
that.
provision in the Sunshine Ordinance that allows action on items not on the agenda in certain circumstances.
But is there something in there that says this is an emergency and this is not? It just doesn't seem binary to
I can look up
me.
the section and provide it to you.
I think we're getting into the merits, so let's start with the petitioner.
Through the chair.
Member Canada?
For transparency, I was at Planning Commission meetings with Ms. Clark voting on different issues. So I just wanted to let you know that I have met her.
Okay. And you feel you can perform your duty? Okay. Thank you.
Yeah, I have to say the same thing. I think Ms. Clark is one of my 1,500 Facebook friends, but so is half this room. So.
All right. Very good on that note.
Hello, everyone.
Okay. And if the petitioner would like to approach. Hi.
You have 5 minutes.
Okay, great. Hi, my name is...
1 moment, please.
Hi, Laura Clark. I think that you're right that this seems complicated, but is actually pretty simple. The Ethics Commission voted on a matter that was not on its agenda on the April 24th agenda. We can discuss why they did that. I believe that it was deliberately politically motivated, but they did it. Starting in March 2017, the Ethics Commission and their staff were aware of the allegations of the conflict of interest. Additionally, during public comment on April 24th, Larry Bush and others urged the Ethics Commission to take this action to stop Commissioner Johnson from participating in the Planning Commission advisory vote. And both the executive director and the city attorney warned them that taking a vote would violate the Brown Act. They knowingly, therefore, took the action anyhow. Chair Keene ignored that advice. The Ethics Commission voted to send a letter telling Ms. Johnson to recuse herself from the vote. During the meeting, the Ethics Commission did not declare a state of emergency. That declaration that it was an emergency was something that they later on used to justify their actions. And they discussed and mentioned the Brown Act and the Sunshine Ordinance's exemptions that Commissioner is relying upon. All of the justifications came later, after I had brought this to the attention that this was kind of an outrage. Commissioner Keene's excuses that this needed immediate action is just after the fact justification that really isn't backed up by the facts. Joe Fitz had stated in his Examiner article on May 9th that he had talked to COP about Johnson weeks ago. We discussed her alleged conflicts and her upcoming votes. The Ethics Commission had plenty of warning that Johnson's allegedly conflicted vote was coming up and plenty of time to agendize that discussion. Joe Fitz is not my political ally. He looks for opportunities to throw me under the bus, and that's fine. I like him as a friend, but he had every reason to find me wrong and to find the Ethics Commission correct. And he, based on his own emails, said that this was BS. The task force, I think that you guys brought up another issue, that you guys are the only body that seems to have any ability to drop any kind of a hammer on the Ethics Commission. It seems to me that they are somewhat of a rogue agency, that this commission does not have anybody, what happens when the Ethics Commission violates ethics? I don't think that you guys know. I think that they've been allowed to be filled with politically motivated individuals who, drop the hammer on whoever they deem to be a political opponent. And that's quite frankly outrageous. They knew well in advance. We have a timeline that starts March 25th when Larry Bush sent the Ethics Commissioners, Keene and Reen, that's staff as well as one of the commissioners, email including reference to the commissioner's apparent conflict of interest. That's as far back as a month before the vote was taken. On March 27th at the Ethics Commission meeting, Commissioner Kopp stated that the commission should address Mrs. Johnson's situation. Obviously, they were ginning themselves up about this, thinking that it was a controversy. If they had bothered to agendize the meeting, then Christine would have been able to come to the hearing and defend herself. Christine had already, well in advance of this, asked the city attorney for their opinion on this matter and would have been able to come and say, I've spoken with the city attorney and this is what the city attorney says. By denying her that opportunity to defend herself, we are denying something outrage. I just think that it's unfair to have a body that is supposed to make sure we all follow the rules and behave ethically, completely ignoring their own rules. Thank you so much.
Thank you. Is anyone who would like to offer any evidence in support of the petitioner? And I will warn you that if you do, unfortunately, you will not be able to provide public comment later, much as we'd like for you to be able to do that. Seeing none. Respondent, please approach. Yes.
Speaking.
Yep. I got it. Thank you. Chair Keene, welcome.
Okay, yeah. Good afternoon, members of the Commission. My name is Peter Keene. I'm chair of the Ethics Commission. As Ms. Fisher said, you have to keep something very compartmentalized here. At the time of our meeting on the 24th, we were told for the first time that 3 days later, the Planning Commission was going to vote on a particular matter having to do with development. We didn't know anything about the matter. I never heard of Christine Johnson before that particular meeting, nor had Commissioner Paul Rennie, nor had Commissioner Dana Chu. Apparently, Commissioner Kopp, Judge Kopp, had heard some things and had made some references beforehand. But it first comes up to us that there is going to be a vote 3 days later, and someone who is now the executive director of Spur, and whose salary and livelihood is dependent upon Spur, an organization which takes issues having to do with development and has taken positions on this matter. She is going to vote as a member of the Planning Commission on a very controversial, very important matter of housing relating to the city. That comes up. Our city attorney says, well, you can't discuss that. It's not on the agenda. There's an exception to that, and that is if something comes to our attention when we do not have time to agendize it. If we agendize it for the next meeting, we couldn't have done anything for what was happening 3 days later at the Planning Commission. There was an exception to that. We were aware of that exception. I said to my colleagues, I rule that this is okay. Should we go with it? Everyone agreed. We then went forward and we heard about it and we said, there is a definite important ethical question raised as to whether or not she should be doing this at this meeting, since she's an executive director of SPUR, and now she's also a member of the Planning Commission and is voting substantively on this. So a motion was made by Judge Kopp to send a letter to her saying, you really should recuse yourself. So that's what you should be looking at, whether or not we had heard about the vote on the hearing 3 days later, 3 days before for the first time then, and whether it was important enough to consider for us as the ethical body looking at it and saying, there's an ethical problem here. You should recuse yourself. We may have been wrong on that, but that's not the issue. It's whether or not we in good faith felt that, and we did. We voted unanimously to send the letter. Under the exception to the Brown Act and under the exception to the Sunshine Ordinance, we complied with what was necessary. We heard about it for the first time then. We didn't have a chance. It would have been futile to agendize it for our next meeting. We had unanimous agreement by the members of the commission that we would do this. The city attorney made that suggestion, well, it's against, you shouldn't do it. I don't want to blow horns here, but on that commission, you had essentially myself, Judge Kopp, Paul Rennie, and Commissioner Dana Chu. That's about 200 years of legal experience. We have the city attorney who every now and then gives us advice. We say, that's very nice, but you don't know what you're talking about. And that was what happened then. I taught ethics for 30 years. I'm the former dean of Golden Gate University Law School. Judge Kopp, when he was in the state Senate, he wrote portions of the Brown Act. You'll have before you today people like Bruce Brugman, who set up this commission and who wrote the exceptions to it, who will tell you what we did was fine. And whatever this political thing is that this woman is involved in with one group or another, we don't have a dog in that fight. We don't care. But for her to say that we don't take ethical considerations seriously is an insult. And we are people who do our best to advise the citizens of San Francisco relating to ethical matters of government. So this complaint against us is totally bogus and is part of some sort of political thing that she's involved in. I don't know what it is. I don't care what it is. But it should not be for you. So I respectfully suggest that you dismiss it. Thank you.
Thank you very much. Is there anyone who would like to speak in support of the respondent?
You want to go ahead? No. Okay.
Yes.
Thank you. Thank you, Bill.
Judge Kopp, welcome.
Good evening, Mr. Chairman and members of the task force. Our chairman has covered the essentials. Let me explain with my words. The agenda of the Ethics Commission is published on Thursday, April 20th. On Friday, April 21st, I learned from a friend of mine of this impending measure at the Planning Commission. I am not a part of that dispute anymore, but that dispute involved whether the city should require developers to include 25% low-income, so-called affordable housing units, or 15%. The Planning Commission doesn't pass such an ordinance. It makes a recommendation to the Board of Supervisors. And just as a footnote, at that time, there was apparently a 6-5 division on the Board of Supervisors as to whether the percentage should be the higher or the lower. A SPUR is a lobbying organization. It may claim to be a nonprofit foundation, and it has a foundation with a nonprofit tax-deductible status, but its membership dues have, for over 50 years or 60 years, which fortunately, unfortunately, I can remember, been a lobbying organization. And it was for the lower percentage of affordable, low-income housing in new developments. When our meeting began, public comment was received. One of the commentators was Mr. Larry Bush, who's the president of Friends of Ethics. He brought the subject up, and as I recall, I said I intend to address that at the appropriate time in the meeting, Mr. Bush, which I did with a very light-handed recommendation that the commissioner, who's director of SPUR for San Francisco, and it's got other branches, simply recuse herself on that one issue. It wasn't an emergency. Nobody's going to lose their life. But both the Brown Act, which Mr. Keene is, of course, accurate about, was rewritten under the urging of a number of Californians, including one who is present in the room now, contains other exceptions besides emergency. Forget about emergency. One of those is if the matter comes to the attention of the commission after the agenda is published. It's simple. And as a matter of
Vice
fact...
Chair Hyland.
You'll have more time. Carry on, please.
Huh?
Wrap up if you could.
All right, I will. As a matter of fact, I didn't know till Mr. Richard Nee brought it to your attention and mine that the city ordinance does have a specific clause about allowing a matter to be discussed when the need for such action came to the attention of the body subsequent to the agenda being posted as specified.
Thank you.
That's the sum and substance up for one footnote. After giving incomplete advice to the Ethics Commission, you talk about an insult. The same attorney then advises the Planning Commission that she has no conflict of interest.
Thank you, Judge Cobb. Thank you. Thank you very much.
Everybody gets special rules.
Yeah. Okay.
Point of order. Ms. Clark, please approach. I'll be happy to give you an additional minute. If you'd like to add more, you may do so now.
I mean, honestly, what I would really appreciate is if the laws apply equally to everyone.
That's at the discretion of the chair, and I ask him to wrap it up. So if you have something else to add, please do so now.
Yeah.
You'll have more opportunity to talk throughout the case and in rebuttals also. But if you'd like to add something now, please do.
I would like to add this document, if that's possible. So this document from friend Larry Bush identifies March. This was sent on the 25th of March, right up here at the top, to Peter Keene as well as staff. So both should have been aware of this as far back as March 25th. There it is, Christine Johnson, and declaring that this should be a conflict of interest raised at Ethics. Who will do it? This body lobbies the Ethics Commission regularly, and I believe, I hope that they read their emails. I think that at the very least, staff could be knowingly, should know that this was an item that had been brought up well in advance.
Thank you. All right. The matter, is there anyone else in support of the respondent? Mr. Planthold?
I'm Bob Planthold, and I'm a former ethics commissioner as well as former longtime member of this task force in separate sessions. You're dealing with process questions, so I want to come back to something I've said at 2 previous committee meetings. If you're going to be talking about being very specific in complying with process, then you also need to look at your own, I will say, negligence, because there's been different committee meetings where there's been no formal specific vote. It's been, even today, by acclamation. My point is that you've got to be careful of what you're doing when you're going to be asked to deal with a process question. But at the same time, the process that you're being told here, at least by the complainant, is drawing unfair conclusions. That there was a letter on March 24th is not the same as saying there was going to be a vote later in April. That's what Chair Keene has said. They only found out about the vote after their agenda was published. That's a difference. The idea that there may be a conflict of interest could be something germinating, but not necessarily needing attention until they find out, oops, there's going to be a vote. That's a key difference. In addition, that Commissioner Kopp had talked of this to Joe Fitzgerald. So what? He's not an officer. He does not set the agenda. The chair and sometimes vice chair do that. So his knowledge is not automatically ascribed to be setting the agenda. It may be helpful for him, but it's not part of the formal process. And now I want to get to counsel. You heard stated that legal counsel for the Ethics Commission got up and said they were violating the Brown Act. Well, that's at best unprofessional. He should have called for a recess and talked to them on the side out of open session. The lawyer is maligning and accusing his own client of violating the law. He shouldn't have done that. That's something I wish somebody would file a complaint against him with the bar. You don't do that to your client. You don't in a trial say your client screwed up. That's another problem. To rely upon that attorney is problematic. And it's not just there. I've talked to the ethics executive director shortly after she came in and told her my experience with this counsel of various areas of sloppiness and neglect on his following process and procedure. So it's not just here, but you've got a client who's not served well by his counsel, and you should not think that counsel is responsive to the needs of the client. He's not being fair, and that's a problem you ought to be addressing also when you consider, was ethics properly served? Thank you.
Thank you. Anybody else in support of the respondent? Keep in mind you can also talk during public comment period.
Thank you. Just to clarify your statement, if you speak as a witness, you cannot.
No, I'm saying you can talk.
Yes.
All
Just
right.
wanted to be sure.
Thought I made that clear. Thank you. Go ahead.
I'm Larry Bush from Friends of Ethics. I did contact members of the Ethics Commission to say that this issue was going to come forward. It is correct that I sent an email about that. But the email was about the general issue of a conflict of interest. That was then responded to by Commissioner Kopp, who said he was interested in introducing a measure that dealt with the larger issue of any commissioner who is funded by an entity that receives donations from those who have a matter before their commission. That was obviously a long-term conflict of interest discussion that would involve an interested persons meeting. It would have required a lot of looking at it. What happened after that was the fact that the Planning Commission issued their agenda showing that they were about to have a vote on this very issue. And so at the public comment section of the Ethics Commission meeting, I said, this is now coming up on Thursday. So this is different from the larger issue of a conflict of interest for the commissioner in general, or any commissioner. It is to the specific issue of a vote coming up on Thursday. That was the issue I raised. It's a valid issue. Commissioner Johnson is being paid by Spur for the last 2 years. She's also been a member of the board of directors. It is true that there was a city attorney, a deputy city attorney, who spoke up, as Mr. Planthold said, inappropriately. What was not disclosed is that the mayor's office had that very same deputy city attorney come and meet with them and with Christine Johnson to give her a permission to vote on measures that were, quote, impactful to the administration. He did not reveal that to the Ethics Commission. What he did was offer advice that was protecting his own private opinion that he gave to the Ethics Commission.
Thank you. Anyone else in support of the respondent?
Good afternoon, evening task force members. Mark Solomon. I was involved in this from the outset, and I think it was pretty clear here that there was no dispositive action that actually spent city money, made policy, or had any other impact than the lightest touch possible, which is communicating from the Ethics Commission that there's a potential ethical conflict going down in the Planning Commission. To a certain extent, this is an emergency because the actions taken by the Planning Commission and then by the Board of Supervisors have concrete, real impacts upon the realities of what goes on in San Francisco and our built environment. That built environment portends consequences to everyone who lives here. And the notion of having different ratios of inclusionary affordable housing is an important issue for San Francisco. It ranks top on the polls everywhere. I think we need to note that SPUR is a developer lobbyist organization that gets money from developers, and the complainant as well is employed by an organization that is funded by developers. We have our city attorney here who gave the inappropriate advice in open session to denigrate their client, who is also involved with a city attorney's office that provides advice to the Planning Commission itself. The levels of corruption here and internecine nesting of conflicts of interest are legion, and the voters of the city and county of San Francisco want to see an activist ethics commission taking a stand for San Franciscans when we have these people fighting over city government largesse to get their own corporate benefits realized. We need to listen to folks here who are not getting paid by developers, who actually have community interests and records in defending the public interest, not people with private particular interests. I urge you all to kindly find this in favor of the respondents. Thank you.
Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. As you all know, I'm no fan of the Ethics Commission. Having every single complaint I've ever had referred to them held in some sort of a bizarre way, like when I was out of the state or some other trick. In this particular case, however, I did speak at the pre-hearing and did say that from what I viewed and reading of the Sunshine Ordinance, I felt what they had done was really in compliance with what the ordinance expected, and to expect them not to take action on something which they felt was ethically questionable on a technicality, I think would be putting them in the position of not doing their job. And I have to say that. I would also like to say, though, that I do not feel the respondent did themselves any favor by labeling this bogus and labeling this political. This was a legitimate concern of a member of the public who felt that an agenda item was not handled properly, that it was not agendized properly, and they did what the law allows them to do. They brought a complaint to this body to allow you to listen to the facts and determine whether you felt that was correct. So to label it or mischaracterize it as some sort of a bogus thing or a political thing is really not doing yourself any favor. It is really kind of thumbing their nose at the task force, which they historically have done for years. They have never enforced any of your rulings at all, not once. They tried one time, and that was it. So they're no friends of yours. And so, like I say, I'm not standing up for them in the sense of I think what they did was right. I think they took actions in a way that could be read to confirm, to comply with the requirement of the law that it was an emergency type situation, and that they did have the votes necessary to do it and meet the requirements of the ordinance. So technically, I do not believe they violated the law. But again, mischaracterizing people's motives and things really has nothing to do with the facts of the case. And I think what should be focused on is the facts of the case, not what people's beliefs are about the motivations of either party.
Thank you.
Good afternoon. My name is George Wooding. I'm speaking for myself. I am the president of the Coalition for San Francisco Neighborhoods, and I've had my own share of cases in front of the Ethics Commission, and I can say I never won one either. But the Open Government Act allows for an exception when there was not time for notice before the agenda was set. And this was just such a time and case. This is very similar to what happens with Robert's Rules. I just want to make some quick points. There is an appearance of conflict of interest to be running Spur, who is a developers group. Gabriel Metcalf, who runs it, he started Hack. People at Hack work with YIMBY. They're all connected if you start to look around, but that's not why I'm here. The real thing with Christine is she had been on the board of directors for Spur for at least a year, and I don't believe she was getting any pay for that. She was doing it for whatever reason. And she was also on the Planning Commission, so she was doing this for quite a long time. Things never became an issue until she started receiving payment from Spur. And then she had a real conflict of interest because now she was heading an organization. And I think one of the things to really look at here, which I have not heard discussed by anyone, is when Christine Johnson started getting paid by Spur. Because prior to that, there was no conflict of interest. And she continues now to get paid by both Spur and the city as in the planning department. That is a conflict of interest. And when she works on certain things that Spur wants, that is a conflict of interest. And people need to know that. There are several boards and committees in the city where commissioners are absent. The city needs to fill her position or replace her position, not because she's bad. She's great at what she does, but because this appearance of conflict of interest serves nobody in the city. Thank you.
Thank you. Anybody else in support of the respondent on this case?
Hello, Michael Petralis. Give me a moment.
Okay.
Thanks, Victor. Hello, Michael Petralis. I'd like to echo what the other watchdogs have said. I think it's incredibly important that we have watchdogs keeping an eye on the Ethics Commission, and I really applaud their incredible volunteer work just keeping tabs on this commission. I'd like to echo what Ray Hart said.
Mr. Petralis, so...
I'll finish.
No, you're talking you're talking in support of the respondent. If you want to make general public comment about the case, that might be more appropriate later.
Gotcha.
Okay. All right. Thanks. Anybody else in support of the respondent?
I'm Bruce Brugman. I'm glad to be here. I'm a founder of this group, and Quentin is right that the Bay Guardian, of which I was editor and publisher and founder with my wife, and I and many, many others, including many here in the room, Rick Nee, Charles Marsteller, et cetera, were behind Quentin and encouraging him to rewrite the Brown Act, which he did. And it was a hell of a good job. It needs to be reformed again, but not because of Quentin. He did the job. We also have the Sunshine Task Force, Ordinance, And in both of those is the exemption. I could read it here, but Rick Nee put it in his letter, and you've got it in front of you. The exemption knocks out anything whatsoever that has to do with whether or not this is a technicality. It's not a technicality. It's perfectly illegal for them to do this. And the Quimby lady gets up and says there's ethical problems with the Ethics Commission and Quentin and Peter Keene and who are they? And oh my God, I thought she was going to go crazy. That Peter Keene and Quentin Kopp are two of the best public servants we've had here in San Francisco for the last 50 years. And I know, because I wrote about them, whenever we would need a quote on a good issue of Sunshine, an honest government, open government, transparency, we would call Peter Keene, we'd call Quentin Kopp. Without exception, almost. They are top-notch people, and they don't need to be put through this kind of thing. There's nothing happened here that was wrong. They were doing their job. They had a notice. They put the letter to Christine Johnson. What is wrong with that? What's wrong with it is what the city attorney's deputy said. Well, somebody should send a letter to Dennis Herrera and say that the deputies that he puts out to the commissions ought to read the Brown Act and ought to read the Sunshine Ordinance before they get up and bellow publicly that they're wrong and chastise them publicly. That's a terrible thing for the deputy to do, and they don't do it in public. They should do it in private. We can't ever find out what's going on with the city attorney on these things because it's attorney-client or whatever it is. But you couldn't find out here from him what his advice was to Christine Johnson on whether she had a conflict or not. He's supposed to be advising the ethics task force, not her. Then they can't find out what it was. In other words, this is a muck. And the phrase that I've used for years, it's very applicable in this case. When the Manhattanization lobby spits, City Hall swims. And this is an exact consequence of this kind of thing. And that's why San Francisco is in such a mess after all these years. With this kind of thing. Turning the Sunshine Ordinance, turning the Ethics Commission, turning Quentin Kopp and Peter Keene and people like that against what they're trying to do for the public interest is the oldest trick in the world here in San Francisco. You should reject this complaint forthwith.
Thank you very much.
Thank you very much.
Yeah. Note to the members of the task force, I got this meeting. Thank you. All right. Anybody else in support of the respondent?
Good evening, committee members. I'm Dr. Derek Kerr, a whistleblower. I've been a critic of the Ethics Commission for 7 years, but not in this instance. Ethics has transformed itself into an open, responsive watchdog agency that actively confronts lapses in government ethics. Its response to pressing public concerns about a potential conflict of interest involving Planning Commissioner Christine Johnson was well-founded. At its April meeting, Ethics received correspondence that had been sunshined by Mr. Bush. It showed that the mayor's office and Commissioner Johnson herself suspected that she faced conflicts of interest once she became Spur's salaried director for San Francisco. The correspondence shows that the mayoral staff debated whether she should resign from the commission or recuse herself. They called upon the city attorney. Unknown to the Ethics Commission, the city attorney opined that Commissioner Johnson had no conflict provided she did not make money from her decisions and as long as Spur did not directly lobby the Planning Commission. But one wonders, why would Spur bother lobbying the Planning Commission since its chief advocate already sat on the commission? In any case, at the April 27 Planning Commission meeting, Commissioner Johnson acknowledged a conflict of interest. She resolved it by promising to recuse herself from housing policy discussions at Spur while continuing to vote on housing policy matters before the Planning Commission. In sum, a potential conflict existed, and it could have affected an imminent and critical vote. The letter sent by Ethics was a good faith effort to fulfill its duty, and it met the immediacy exception allowed by the Brown Act. And unlike the Sunshine complaint before you, all it urged was recusal, not resignation or criminal prosecution. Thank you very much.
Thank you. And this is in support of the respondent.
Yes. Good afternoon, Commissioners. I'm Charlie Marsteller for the record. I'm not here representing Common Cause today or, frankly, Friends of Ethics, now a group I'm involved with, but that's what I'm known for. First off, I have a long history with this body, being active with them. This is ethics for many, many years, decades. By the way, we just filed our files with City Archives, so if anybody wants to read about what's going on in the city, our files are now available. I wanted to say that ethics was founded to be non-political and non-partisan to the greatest extent possible. Each commissioner has a different appointing authority. They cannot communicate behind open meetings, and they have high standards and ethical and moral conduct when they're appointed. It's a great honor. It's a quasi-judicial body. So they're like a judge. So they handle it accordingly, and this is their attitude when they're appointed. They cannot be politically engaged. They cannot be active in political organizations. They are restricted on the amount of activities of fundraising or for donation. And speaking of that, that leads me to my second point. If you look at the SPUR website, you will see a bio written about this new appointment of Ms. Johnson and what her duties are, and one of them is as a fundraiser for SPUR. So I think it's very clear that ethics was acting as quickly as possible and as proactively and concurrently as possible, given the circumstances, to just simply advise her of a potential conflict. And I'm really surprised that the commission is here before you on this matter. I'm sorry it wasn't adjudicated at a subcommittee and dispatched accordingly. But thank you for your consideration.
Thank you. Is anyone else in support of the respondent? Seeing none, this matter is before the task force. Member Moss?
I have a couple questions for Mr. Keene, but before we get there, I was wondering if DCA COLA could shed any light about where this might go.
Do you have a specific question for him?
I'd asked earlier about just theoretically if we had come to a willful violation, where we would have to take this off, where we'd have to send it.
The only thing the code provides for is that it would be referred to ethics, which clearly wouldn't be the right play here. I need to get back to you with an answer on that.
Okay.
I think you should move forward and determine whether or not you think there is a willful violation, and we'll cross that bridge if and when we get to it.
Okay, great. Thank you.
Okay, thank you.
Mr. Keene? So I'm going through our packet here, and I was looking at your minutes, and the motion that was voted upon said that the letter is to include a preamble recognizing the Ethics Commission's actions as extraordinary and necessary due to the upcoming vote by the Planning Commission on Thursday, April 27, 2017. On page 90 of our packet is a copy of what I believe is the letter that was sent out, but I'm not seeing a preamble that discusses this extraordinary and necessary measure. Can you tell me where I might find that?
I don't think you will find it. What happened was that after we voted on it, there was a collective set of heads that got together, the Executive Director Pelham, myself, Judge Kopp, and came up with particular language which we thought was appropriate in the letter.
So, I mean, under the Sunshine Ordinance, a two-thirds vote needs to occur that any action is going to, that it's necessary in this emergency capacity. Was such a vote taken prior to deciding on the letter?
Yes. I have to frame it this way. In terms of what we do, Mr. Plano was talking about process, and every commission, just like yours, has a certain amount of process, sometimes formal, sometimes not formal. When it was raised as to whether or not we should take this up, and the city attorney said, well, you can't do it because of it's not on the agenda. At that point, as I said earlier, I said, well, I'm going to rule that we can take it up, and sort of indicated to my colleagues, that's what I'm going to do, and discuss it, unless there's no objection. And there was no objection. So in terms of our process, maybe, in terms of was there a formal roll call vote at that point? No, but there was a vote.
So just as so I'm going to read you the ordinance, and you tell me whether this occurred or not.
Okay.
Upon a determination by a two-thirds vote of the members of the legislative body present at the meeting, or if less than two-thirds of the members are present, a unanimous vote of the members present, that there is a need to take immediate action and that the need for action came to the attention of the local agency subsequent to the agenda being posted as specified in subdivision A. Did that occur?
That did occur. It was not a roll call vote. And I got a sense of my fellow commissioners that they wanted to go forward. They did not say they did not want to go forward. There were 4 of us. I took that as a unanimous vote. Then later on, we did have a roll call vote. 4 members said, yeah, we should do this. So in a sense, that then ratified what we had been doing all along. So,
well, I just want to be clear, because I want to make sure I'm understanding. So you're saying there wasn't a roll call vote, but you are taking no objection as a vote.
I'm taking, yes, that's exactly what I'm saying. Given the nature of the way our commission had functioned, just as Mr. Plano has indicated things about the nature of this commission had functioned, that in terms of myself and my colleagues, I see I'm the chair of it, but I don't put myself in any kind of imperial position. So when something is proposed, I look around, and my looking around is this okay with you all? Is this cool? Will you vote for this? And everyone agrees. So that was a vote, not in the formal Robert's Rules of Order, call the roll, but it was a vote. And we had unanimous consent to go forward with it. That's the only way I can answer it.
Okay, thank you.
And Chair Keene, at the end, you did have a vote to send the letter?
We did, and it was unanimous. All of us agreed.
Okay, hold on one second.
Sure.
Member Tesfaye was next.
Right.
I think she might have some questions.
And I have a question both for you as well as the petitioner. She can.
I'm sorry, I can't hear.
I have a question for both you and the petitioner.
Sure.
Same question. So, can you tell me a little bit about what would have occurred had you not taken this vote?
What would have occurred would
had you not sent this letter?
Okay, what would have occurred would be that the Ethics Commission had failed to carry out its duties under the charter mandate that the Ethics Commission has, that we are to oversee San Francisco city government, and if there are things that are going on that we believe are unethical, we are to address them.
Okay.
And to advise the citizens of San Francisco that, in our opinion, this shouldn't happen.
What did you think would occur at the Planning Commission had you not taken this action?
I have no idea what would occur at the Planning Commission. I didn't care. I don't know about the Planning Commission. I've never followed the Planning Commission. I still don't follow the Planning Commission. I don't follow Christine Johnson. I still don't know who. So I have no idea. But I know that what would have happened would be that a city agency charged with giving an important vote, as we were being, this is the information we were getting at the time, on questions of housing, low-income housing, other types of things, would have had a vote by a member of the Planning Commission that had a direct conflict of interest because she was being paid by a group that had a particular stake in that action. That is a classic conflict of interest. For the Ethics Commission to not address that, we would have been derelict in our duty, and we would have violated our oath when we were sworn in to faithfully fulfill our duties as ethics commissioners of the City and County of San Francisco.
And so I guess my specific question is the reference that has been made a few times tonight to Section 67.7E2, Part A. The need to take immediate action on the item is so imperative as to threaten serious injury to the public interest if action were deferred to a subsequent special or regular meeting or relates to a purely commendatory action. So I need to know what information you had before you that made you think that there was a threat to that there was serious injury to the public interest at stake that would require you to take this action without having it placed on your agenda as required by the ordinance.
And as I said, there would be serious injury to the public and to citizens of San Francisco if some sort of unethical action was taken by a city agency in regard to a very important matter. That we were aware of, and that was what we were addressing.
Okay, and I would like to hear the response from the petitioner to the same question.
Yeah. So this was an advisory vote. So if they had done nothing, things would have proceeded, and it would have been another advisory vote. I don't know how many people followed the whole inclusionary debate. I followed it closely. But there were many advisory votes on various aspects of this. This was not a super urgent one of many. It was a sort of last wrap-up, put the bow on advisory vote before it headed to the Board of Supervisors, but it did nothing about policy and had no impact on the public welfare, in my opinion. I also want to say that I think it's a little bit unfair of you guys to be asking you now to try and figure out if it is a state of emergency when they didn't vote to declare it a state of emergency. It's difficult for you guys now in retrospect to try and decide that.
So I have another question for you on that same topic, follow-up. As to this advisory action that you were saying. So had that vote been taken by the commission without this letter being sent by the Ethics Commission, and the Ethics Commission had put this on a later agenda and voted out, then the Board of Supervisors could have used that information before they acted on the advisory recommendation of the Planning Commission?
I would paint out a different timeline. What would have happened, they would have put it on the agenda. Christine would have been able to come and state that the city attorney had informed her that everything was kosher. She would have been able to mount a defense, make the argument in front of the commission. And because of the advice from the city attorney, I believe in all likelihood they never would have sent the letter because they would have received the necessary evidence to determine that there wasn't an ethical violation.
That's enough. Thank you.
Thank you. Member Kanata?
Yeah, I have a question for Chair Kane. I definitely agree that that some information should have been sent to Ms. Johnson because I believe there is a conflict of interest. But my question is, you got an email from Mr. Bush about a month before your meeting, so maybe 5 weeks before the Planning Commission meeting. The Planning Commission meets every Thursday. They vote on housing issues almost every meeting. If ethics really thought there was a conflict of interest, why not agendize it as soon as you got this email and decide what to do with it? Because you had mentioned in your words, I think you said this was a big vote. For citizens of the city, every vote on housing is a big vote. So I'm just wondering why it took this one vote that was going to come up before ethics took action. And if you had agendized it, we wouldn't be here.
Well, once again, I can only reiterate, I had never heard of Christine Johnson. You have an email that was sent by Friends of Ethics, which is sort of like there are tons of emails that members of the commission get from different bodies, one of which is Friends of Ethics, and it was sent to me and to the members of the staff. And there is in that email, buried in that email, a reference to someone named Christine Johnson. Now, I have to confess, I'm really sorry. I didn't scrupulously read the email from Friends of Ethics a month before and their references to Christine Johnson because I had no idea who Christine Johnson was. This email that you're talking about was an email that I turned over to the complainant because she asked for any emails that I had which related to Christine Johnson. Going through my emails, there was one from Friends of Ethics, a blanket email to lots of people. Buried in that was a thing about Christine Johnson. I have no memory of that. I'm sure I never even read it. And I certainly didn't have that in mind on April 27th, nor did Commissioner Rennie nor Commissioner Chu. And again, Commissioner Kopp, his particular knowledge with this reporter, you can't impute that to the committee. But the email notwithstanding, I never heard of Christine Johnson. I didn't know who the heck she was.
Okay.
Right?
Thank you. Member Wolf?
Commissioner Keene, if you can...
Sorry, you're being summoned again.
Very good.
So let me ask this question carefully. Would there have been anything wrong with having taken a more formalized motion and vote about declaring an emergency or acknowledging this as an emergency issue, as opposed to the sort of ad hoc consensus method that you had used?
No, not at all. And I admit to you that it would have been better to do that. And that's what I should have done. But that is a very small matter of form over any kind of substance. I should have done that. And in that sense, I was lax as a chair. And I admit to that, and I apologize.
Great. So I'm not convinced at this point that is within the scope or not of our particular board to deal with the procedural elements. But my final question is, based on what you just said, the next time something does need to be dealt with on an emergency basis, will you go forward with a roll call vote?
I darn sure will. Because for one thing, I've been involved as chair of many things. I was the president of the San Francisco Bar Association. I was a vice chair of the State Bar of California. I was on the police commission. I've chaired many things, and this was the first time that I was ever in a situation. I knew that there was this exception to the Brown Act, but this was the first time I had ever had it come up before me. And because of that, and because of the fact that the city attorney, who was, I don't want to pass the buck, but I'm passing the buck, who was supposed to be advising us, and he should have advised us, yeah, there is this one way you can do it, and there's this exception, but you should do these things, including what you said. Take a formal vote. If we had had an honest city attorney's opinion in regard to it, guiding us, I wouldn't be in this position. But I still am guilty as the chair, because the buck stops with me. I should have maybe called a timeout, looked at, make sure I was dotting every I and crossing every T. So I was lax in that, and I admit it.
Great, thank you.
All right.
Any other members of the task force have any questions? We can move to rebuttals also, but and you can still ask after that. Member Eldon?
Yeah, I mean, the real issue to me is the timeline of the knowledge of the Ethics Commission about Christine Johnson and her potential issues. And it's hard for me because on the one hand, you guys, like, she's clearly on a lot of radars in this room and has been for a while. And it's no secret who she is, but at the same time, there's no evidence that the specific vote that was coming up in front of the Planning Commission was something that had been shared previous to the Planning Commission agenda coming out. So I have to believe that maybe you don't know who Christine Johnson was, but I have to believe pretty much everyone else does because of all of the reasons that were explained by the people who are criticizing her. But on the other hand, we don't have... We're sort of, I mean, and the other thing that we talked in the subcommittee is that Joe Fitz's article, the timeline where he said weeks ago, and it was like 2 weeks after the Ethics Commission action, that didn't really seem to be evidence because it's like, well, that was two weeks after the fact, so it's hard to say what that means. But the March 27th thing, it's like, well, either Christine Johnson's a big deal that you guys should be flagging, and a lot of people seem to feel that way, or she's not. And I guess I am really struggling with that aspect of this. I don't know if there's really a clean way to decide it because we don't have all information about what everyone knew at the time. It's sort of circumstantial. But that is really the crux of the problem to me.
Thank you. Yeah, member testify.
Can I ask one more question to Chair Keene, please? Can you give us more information? I know there's some information in the packet, but give us more information as to how this matter was brought to your attention that made you want to take the...
It was brought to our attention by Mr. Bush on at the time of the meeting in public comment. He raised it, and we heard of it for the first time. At which point,
and was there anyone there to speak on the other side of that issue?
I don't know. I have no idea whether anyone was there to speak on the other side of it.
I mean, do you remember anyone else?
No one
there?
did speak on the other
that's what I
side
meant.
of it.
Yeah.
Right.
Okay. Thank you.
Okay.
Thank you.
Okay.
Should I sit down or stay here?
I think we're...
Okay.
Actually, we're going to probably move to rebuttals next, in which case you would go first. So if...
I'm sorry?
We're going to move to rebuttals, so if you want to wrap up, kind of, you have 3 minutes to provide your rebuttals on your case, and then we'll hear the same from
All right,
you.
I won't take the full 3 minutes. I appreciate the hearing that you have given us, and I appreciate the fact that you have been attentive to what we've had to say. In regard to Mr. Eldon's statement about not being able to make a determination relating to the timeline, I do say that you have evidence clearly before you that we didn't know what the timeline was, and that is you have my statement to you. I mean, if you were to take that not as evidence, which you can, you'd have to look me in the eye and say, Keene, you're lying, and I believe you're lying. Now, no one has ever done that to me in 50 years of of being a lawyer, trying as perhaps 150, 200 criminal cases as a deputy public defender and chief deputy public defender, representing people accused of every kind of crime, defending people who were charged with death penalty cases, every other type of thing. No one has ever accused me of that before. During that, or during the 30 years as I was a teacher and a dean of a law school, or when I was on the police commission, or when I was president of the board of chair of the San Francisco Bar Association. So I would hope that's not what you're doing, that you were deciding as evidence, Keene's a liar. Therefore, the timeline is that they knew about this and they were setting up this woman, Christine Johnson. If you believe that, there's nothing I can do. But I certainly hope that you don't. Thank you.
Thank you. Member Eldon, did you want to clarify what you meant? Are you okay? Okay. All right. Please go ahead. You have 3 minutes.
So I've had my character thrown under the bus today a little bit, which is fine. I'm quite accustomed to it. I would like to say that I'm here because I'm friends with Christine and because I struggle to engage with the extremely difficult process of local government. I organized mostly working people who struggle to get to hearings, to struggle to figure out when these hearings are and what will be discussed. It is extremely difficult to engage with local politics in San Francisco and come out and give public comment. I've brought other friends here who all have full-time jobs and are doing this because I badgered them and because they care about Christine as well. Local politics is personal and it's not very nice in San Francisco, and it's very difficult to get out to these hearings and to make sure that the law applies equally to everyone. And I haven't had 30 years to accumulate power in local government. I'm new, and I guess that makes me suspicious. But I would say that Commissioner Kopp has demonstrated all of my points, that he has expressed his personal feelings about the nonprofit Spur, about how he thinks that they are unethical as a group and should be treated with suspicion. And additionally, they have admitted that they did not take a vote to declare a state of emergency. They said to a certain extent it was, or there was no emergency. I don't have 200 years of legal experience. But I do think that I'm happy to be in the company of the city attorney who has been declared dishonest during this hearing. But I don't think he is. I think that they do the best they can to give the best advice they can, and I do the best I can to engage with this process, which is extremely difficult. Thank you.
Thank you. Members of the task force, Member Ross, you have something to add?
I'm ready to make a motion if that's
Please
all right.
go.
So,
there will be public comment on the motion. Yeah, go ahead.
So, I mean, there are a lot of issues here, but I think they all come down to the same violation, which would be I move to find a violation of 67.7.
Seconded.
0.7. Any specific?
The reason I'm saying broader is because it implicates D and E, and so it's difficult for me to say it's a violation of 67D because the exceptions to 67D are in E. So I'm just saying 67.7 for the sake of clarity.
Okay, so the motion is 677, seconded by Member Tesfaye.
And I can explain more if people want to hear more. Yes.
Yeah, go ahead.
So there's two ways to look at this, or there's two issues here. One is whether they could do this, and the other is whether they went about it the right way. Now, for me, I believe that that Mr. Keene has admitted that he did not go about this the right way, that a vote should have been taken to say that this is required because we have new information, and then they should have had public comment on that and then voted on that. And if they said, yes, action should be taken, then they should have discussed what the action should be, what the nature of the letter should be, and then done another vote on that letter. Instead, he said that he just assumed that no objection was the same as a vote, and that wouldn't fly in this committee, and it shouldn't fly in committees in general, that a vote, if it says a vote needs to be taken, a vote needs to be taken. And so that's kind of where, I mean, there's a lot of gray areas here, but for me, that's where it isn't gray. He said that he probably made a mistake and he would do it differently, and so that kind of seals it for me. As far as the issue of whether they could do this regarding the issue that they needed to find that the need for an action came to the attention of the body subsequent to the agenda, we've heard sort of two explanations. One is that, well, they only heard that this upcoming vote on this one particular item, which was part of the public which was raised during the public comment, they only learned that during public comment. But the actual letter that they put out referred to the whole meeting and any actions taken during that meeting. And I think that everyone knew, based on the previous letter, that this person sat on the Planning Commission and regular meetings of this Planning Commission did happen. Again, I think this is a gray area and there might be different opinions on this, so that's why I kind of defer back to the process issue. I would also add that it does concern me that the vote called for a preamble to be done in this letter to lay out the decision that this was a necessary urgent measure, and that did not actually come to fruition. So a vote was taken on an action that actually is relevant to this, and that was never put in writing per the vote.
Member Wolf?
So I think I agree with the concerns that you raised around what happened. My hesitation to move forward with finding the violation that you have recommended is that it seems to me that there was probably more something along the lines of a violation of Robert's Rules of Orders by not taking that vote, as opposed to explicitly within the way that the code for the Sunshine Ordinance is written. At the end of the day, the fact that I don't believe that a public comment would have been necessary for deciding after they voted to call this an emergency. And so because the vote ended up being unanimous for this, I think it's unfortunate that there wasn't a voice vote, but that at the end of the day, it still would have come out the same if these four people voted for an emergency. Voted to move forward with this, they would have also voted for the emergency. So I think there were some things that weren't done well, and I don't know what the best public policy group about following the best civil policy and Robert's Rules of Orders and stuff is, but I'm not convinced that it is this body.
Okay, Member Tesfaye?
I just have a few comments that are in support of the motion, and I'm going to go to the two-thirds question, the vote last. But first, there is an A and a B to 67.7E2. The first part being that there needs to be that immediate action on the item is so imperative as to threaten serious injury to public interest if the action was deferred to a subsequent special or regular meeting. And, here we have information on the record that the threat to serious injury to the public interest, that information is very weak. There's information on the record that explains how this was an advisory vote, that subsequent to this vote, that action would need to be taken by the Board of Supervisors. And given that kind of information, I can't say that there would be a serious injury to the public interest had an action not been taken immediately. And then the next issue is the B. The need for such action came to the attention of the body subsequent to the agenda being posted. I don't think that it's fair to say that Member Eldon or anyone else is saying that someone was lying about what they knew, what they didn't know. And I think that the arguments in favor of that prong, that required prong being met, are very shaky. There are issues there of maybe they didn't know, but maybe they should have known. And that's not something that we need to get into because the information that we've received on B is so shaky that I would not feel comfortable saying that it was met. I'm not going to say that someone knew something or didn't know something, but there's not information on the record to show that B was met by the Ethics Commission. And then on the issue of the 2/3 vote, Chair Keene said that he would do it differently, and I really trust that that would occur. But in a situation where a complaint has been filed on this issue, if a complaint had not been filed on this issue, I would not have proactively gone out and said, where has the Ethics Commission or any other commission not taken a roll call vote when they should have done that? But in this case, we're working on a complaint matter, a quasi-adjudicatory matter, and so we need to look at what has occurred. I trust that in the future something else will occur. But since we're looking at the past, what has occurred in the past, we can't say that that requirement had been met. So with that, I'm still in support of the motion by Member Moss, and I would like to hear public comment on that issue. But I'm feeling very strongly, and I wouldn't have made these comments had Member Wolf not shown some hesitation, but I really felt like I needed to speak in support.
Okay. Let me just offer a couple of thoughts on the other side of this. Two things. I'm not sure that the Ethics Commission at the time knew that it wasn't a substantive vote the Planning Commission was going to take place. They just acting purely on the information presented at the meeting at the time. And if that's the case, if you take that at face value, they're acting, as they should have. And as far as the voting on the on whether it was an emergency or whether it was, voting on the exception to the Brown Act, as you heard Chair Keene say in his 50 years of chairing committees and legal work, this is the first time this came up. This is a very, very small piece of the code, and not everyone can be expected to know that. And I would characterize the fact that perhaps he just took the temperature of the room, and at the end of the day, there was a vote unanimous to send this letter. That was the action. To me, that satisfies having a vote on this. That's just my personal opinion. So I just wanted to give that to the task force. On that note, why don't we take some public comment on the motion as it stands? Everybody good with that? All right.
Good afternoon, task force members. I'm Richard Nee. Just a few things. First of all, on the question of where this would go if it does not go back to ethics on a willful violation, there are three other entities where you could send it. The Board of Supervisors, District Attorney, and the California Attorney General. Now, historically, what has happened when matters have been sent to the Board of Supervisors, they've been ignored. When they've gone to the district attorney comes back and says, for me to do anything here, I would have to see evidence of criminal activity. I don't see that here. The state attorney general will typically kick it back with a note saying, this is a local matter, we don't handle it. So there are your choices. On the question of deputy city attorney's advice, and with all due respect to your Deputy City Attorney, Mr. Cola, it is just that, advice. It does not constitute a body of law. Finally, again, having seen the minutes of that April 24th meeting and having heard the testimony presented today, I remain convinced that the action that the Ethics Commission took on April 24th was justifiable under Sunshine Ordinance Section 67.7E2.
Thank you.
Good evening. Thanks for having us here. My name is Sam Moss. I'm here personally today. I just want to point out for everyone that there is a business manager of the Local 6 union on the Planning Commission. His sole job is to ensure that more construction happens. There is the head of the Fisherman's Wharf Business Association, whose job is to make sure that business-friendly decisions are made citywide. There used to be number 3 at a very large nonprofit affordable housing developer. I could go on and on and on. There's been realtors. So to say that this one woman had some conflict that was going to be world-ending that had never happened before is like new levels of hypocrisy, even for San Francisco politics. And so, just to close out, one of the board members at Spur is the head of another affordable housing developer. So one of Christine Johnson's bosses actually is pushing for higher inclusionary rates. So, to say that this was just this emergency it's just false. And I just hope that everyone takes that into account while you're making your decision. Thank you.
Thank you.
Hello, members of the task force. Nice to be back. So a couple of things. I first would like to say that I would thank Mr. Chair Keene and Judge Kopp for their many, many years of service to the community. That what they've done, I don't think anyone is here saying that they have not been great public servants. I would think that, there are many, many years of experience would actually have informed them to perhaps handle this situation in a little bit more of an experienced manner. I do not think one declares an emergent situation without hearing from two sides of an argument. To just say and I'm a little bit concerned, or I would push back on what Chair Hyland said, that, well, maybe they didn't, just the information they had at the time, therefore it was, justified. To declare an emergent situation? They might have just had some wrong information at the time. That is concerning. The other thing is I would also like to build on what Sam Moss just said. The former chair of the Planning Commission was Cindy Wu. Cindy Wu works for the Chinese Community Development Corporation. She voted on projects that her nonprofit got paid to do. And I find it very, very hard to believe that people like Larry Bush, Bruce Bergman, Bob Planthold were not aware of Cindy being on the commission and there being a conflict of interest. This, whether Mr. Chair Keene recognizes it or not, and he might very well not be, he was used for a political vendetta. That this is not about conflict of interest. This is about old white men not liking Christine Johnson. That's what this is about. And I would also like to state for the record that Mr. Bergman in the audience tried to intimidate Ms. Clark by saying that she is being hysterical. And I would hope that you, as the task force, would say to people in the audience, please be respectful to each other, that there is nothing wrong with Ms. Clark bringing this forward and asking that. So, I think that this is clearly, I would think that if Mr. Keene was teaching in one of his classes, I think he would say, this might be a case of selective prosecution. That this is one person serving on a board that many, many other people have served on, having a similar situation, but this is the only person they've gone after. And just as my last thought, the inclusionary was scheduled to be heard on April 6th and April 13th also. but no state of emergency was declared for those. Thank you.
Thank you.
Hi there. I'm a little bit sick, but hi, members of the Sunshine Task Force. My name is Nicole. I'm a law student here at University of San Francisco. I've been following this issue, and honestly, as somebody who came to San Francisco, is really excited about the change that can happen in San Francisco, especially kind of the justice that I see with a lot of the policies here. I'm really disappointed to see this political witch hunt, especially for a minority female woman on the Planning Commission. It really makes me sad. This is clearly politically motivated. This is about abusing power, and there's absolutely no oversight when the Planning Commission messes up. Additionally, when I took a look at this issue, I've seen that every planning commissioner has these conflicts of interest, and it's sad to me that that a female and African American planning commissioner ends up getting kind of the ream on this. Ultimately, I would hope that it's so clear to me that this is a political witch hunt. I would really hope that when you're making your decision today, you take into consideration the integrity of the law. I'm just a student in law school, but this really disappoints me. So thank you.
Thank you.
Good afternoon, members of the task force. My name is Corey Smith. A couple of quick things just want to clarify regarding this inclusionary discussion. There were two proposals in this, again, highly political debate. One was 18%, the other was 24%, the lower of which was in the economically feasible range. It was assumed earlier that that was the position that Spur was supporting. I don't believe they ever took an official position, but that number was unanimously supported by the Board of Supervisors later on. The 24%, again, was outside of the economically feasible range in that aspect of it. Just to going back, and not an attorney, but I think it's just some common sense stuff on the timeline here. On the 25th of March, I received an email from Larry Bush and the received an email from Larry Bush and the Friends of Ethics that was apparently ignored, which I think is another kind of issue on its own, but kind of putting that aside, assuming that it was actually taken up, the item that is being that brought all this to head again was actually on the Planning Commission's agenda on April 6th, and then again on April 13th, as well as all the other things related. You took my talking points earlier. There's so much stuff related to housing at the Planning Commission. I'm there every week. And at no point in time, any of that raised a red flag. But then all of a sudden, at the last second, without any notice to anybody, well, now it's a really big deal. Now we need to take emergency action because there's people that could be at risk here, even though it was, unanimously supported later. It just doesn't smell right to me in too many ways. I hate using the phrase, but it does seem like a political witch hunt for political purposes. Whether that was the intent of the Ethics Commission or not, that is, to me, what makes the most logical sense. So thank you for your time.
Hi, I'm Elena Schmidt. I am associated with Friends of Ethics, but I'm just speaking as someone who's been sitting through these hearings, both the Ethics Commission hearings and the one you had previously and the one today. I would go back to how Victor started your meeting. When you asked, what is this all about? He said that it was about two things. He said it was about the allegation that they knew before the agenda and whether they had had the ability to take the action that they took. And I think let's take it at face value that the people who were voting on this issue did not know the person who they were talking about, only knew that an issue was coming up the day before. They hadn't done any research on what's before the Planning Commission all the time. All they knew was that they were confronted with an issue of conflict of interest. And what they were supposed to do as Ethics Commissioner was deal with the conflict of interest that was in front of them, which is what they did that evening. And the question of whether they knew or didn't know, I think you have to go to what the commissioners indicated that this was new about the issue that was coming that was coming before the Planning Commission a couple of days hence, and they were voting on the face value of it. Also remember, one of the things that Commissioner Keene said that I thought was worthwhile reminding you, which is this was an issue that was confronting them immediately. They did not have time to do any research. The city attorney did not give them any guidance on how they should be doing it. So they had some knowledge about that they should be taking a vote and make sure that it was unanimous, but there was no procedure in front of them that either Commissioner Keene had ever had in his experience or that the city attorney was giving them that night to tell them an accurate procedure. So they did the best they could in the few minutes that they had to deal with the issue. Thanks.
Thank you. Is there any other public comment on this motion? Are you waiting, ma'am? No, okay.
Hi, Michael Petrellis. If I understand this correctly, we're talking about several bodies involved in this complaint. The Ethics Commission, the Planning Commission, the City Attorney, and now the Sunshine Ordinance Task Force, right? 4 very important bodies are part of this complaint. And yet, no, well, they're weighing in on it. They have some role to play in this matter. And yet, that TV screen is not showing any of it. None of what has been discussed here is going to be shown on TV. And the disservice to the public, to everyone here at City Hall, to everyone who is interested in housing in San Francisco and how the housing policies get made, how ethics operates, how the city attorney advises, what planning does, none of the important matters that have been discussed here in the past 2 hours or so are going to be shown on San Francisco government TV. Yet there are cameras in this room. This sunshine body needs to have sunshine. It needs to be on government television. Everyone who's behind me needs to go and talk to everyone at the Board of Soups and the mayor's office and say, turn on the cameras, turn on the microphones, let the sunshine in at the Sunshine Ordinance Task Force. That's what I want to say. Thank you.
Thank you for that support. Thank you. Anybody else have any public comment on the motion before us? Seeing none, public comment is closed.
On that motion, to find a violation of 67.
Hold on 1 second. Member
Can I just have a
Kanata?
clarification? Because
Sure. Yeah.
some of the public comment from Richard Nee was about where to go for willful. This motion is not for willful, correct?
I have not made a willful motion
Okay,
in my
thank
thing.
you.
Okay. All right.
On the motion to find a violation of 67.7, Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
No.
Hinsey, no. Chair Wolf, absent. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
No.
Wolf, no. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Acting Chair Hyland.
No.
Hyland, no. The motion fails.
Okay. This matter is concluded.
The matter is concluded. No violation was found on this matter. Next on the...
Thank you, everybody, for your time. Appreciate all your words.
You want to give it a minute to clear out?
Yeah, I think we just... Should we take a... Yeah.
Yeah.
Vic, let's take a 10-minute recess.
We'd like to take a recess at this time for 10 minutes.
Clear the room and then... Well, back this meeting. Back to order. Okay, so we still have quorum? We have quorum.
We still have quorum.
I thought he was leaving his phone here, so I was going to stop. Okay.
All right.
I'd just like to note that Member Josh Wolf is in attendance at this time, and Member Eldon and Member Fisher have had to leave for personal reasons.
Okay. Member Wolf arrived some time ago. All
Next
right,
on the agenda.
So we do have a quorum of 6 people. And go ahead, Victor.
Item number 6, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and I believe that as a matter of principle, you should quit this meeting and go home. Right now, the complainants have to get 100% vote to prevail. That means the respondent has to lose only one vote to prevail, and that is not equitable. Having to get 75% of the vote, which is really why the last motion failed, it wasn't because it wasn't a substantive motion, it was because you didn't have enough members so that you could have a majority of the sitting members have enough votes to make it pass. And when you start making decisions based on that rather than on the law, it's wrong, just wrong. Now, I'd like to say something about the Ethics Commission. I find it, Member Moss said he was kind of surprised to see me arguing on the side, and I'll be honest with you, I was too, because I'm no friend of ethics. Ethics has never, in my experience, ever said a kind word about the Sunshine Task Force, what you do, how you do it, or anything else. They have been nothing but deprecating and dismissive of every single action that has come to their attention. For years, you have been sending things to the Ethics Commission, and they have attempted to enforce one. In all those years, one determination. Every other one they dismissed for procedural grounds or held it in a strange situation. The ones that I got to a hearing, they held one while I was out of the state, and they knew I was out of the state because I had informed people that I was going to be out of the state so that I wouldn't be placed on an agenda while I was gone, and sure enough, they had the hearing. The second one was against the library, and the library was found in violation, and the Ethics Commission, when they were holding the hearing, had also been found in violation for the very same thing. Gee, what a conflict of interest. We're having a hearing to determine whether a city agency is in violation of something that we have also been found in violation. If we find them in violation, we have to acknowledge that we're in violation, but if we find them not in violation, we can say we're not in violation either. The interesting thing about that is both the Library Commission and the Ethics Commission subsequently changed their behavior because it related to the 150-word summaries. And in January of 2016, without taking any discussion either at the Library Commission or the Ethics Commission, they started to take the 150-word summaries, my constitutionally protected political free speech, and started to put them in the minutes where this task force had been ordered them to do it for 4 years. The Ethics Commission needs a comeuppance. And the fact that Quentin Kopp and Peter Keene have distinguished careers of public service doesn't give them extra privileges above and beyond the citizens of the city and county of San Francisco.
Is there any other public comment not on items on the agenda? Seeing none, public comment is closed.
Through the chair?
Yes.
I hate to open this up, but the point that Ray Hartz made about his cases and the other cases needing a complete unanimous decision does kind of make me question the validity of the decisions that we come out with if they don't happen to be unanimous. And I don't know whether that means that we should be open to reconsidering them in the event that people aren't happy or what, but it does make me nervous.
Member Tesfaye?
Yeah. And we've already taken a vote on the last item, but I mean, I feel the same way. And that's why the last item went the way it did. So I feel for Mr. Hartz, I guess, but I feel for what happened on the last item as well. So I don't know.
And Victor, 1 second. Did we, I'm just hearing about the members' absences or needs to leave and whatnot. A lot of it, 2 of them are medical emergencies, and then not sure why Lou Fisher left. But was that something that was being discussed with Chair Wolf before this meeting?
Most of the absences occurred at the last moment. I wasn't aware of them until an hour or 2 before the meeting.
Okay. All right. Member Canada?
I don't want to have my comments based on anything that's happened tonight, but I've thought that I'm into my second year here. July was the beginning of the second year. And my feeling is that we need, as a task force, to address this issue, because I don't think it's fair either that if only 6 of us are here, you need a unanimous decision for one side to prevail, and that, you know, if there's less than 9 or whatever a number comes up with, then it should just become a majority. In my feeling, it should just be a majority.
That would entail amendments to our bylaws.
Right.
And however, my suggestion is that either party of one of these complaints can ask for a continuance. This task force can vote on that, whether or not to allow continuance or not. However, if an item is continued, I do warn that it will be a very long time before we can reschedule it due to our backlogs.
What are we talking, a couple of months, 3 months?
At a minimum. We have been receiving many complaints, and the backlog is getting larger.
Okay. And just to give some history for the members of the task force that haven't been here as long, we have at times operated with a skeleton task force when we had a backlog 3 times as large as this. I still think we did good work, but the points you guys are making and members of the public making are valid. So why don't we do this? Why don't we ask those in the room that have waited patiently for 2.5 hours whether they'd like particularly the petitioners, because I think the onus is on them, the way we're structured right now, if they'd like that continuance. So I'll start with Mr. Hartz, who's at the end and has 3 cases.
Yes, I have 3 cases, and I would like them all continued because having to get 6 out of 6 it's just unreasonable burden.
Okay. So let's take it piece by piece.
One at a time, yes.
Yeah, so can we take a vote on that?
There's requests from Mr. Hartz to continue items number 9, 10, and 11 to a future date to be determined.
Okay. And Member Wolf?
Does this become a motion with public comment, in which case we should hear all of them and then deal with it at once?
Good point.
We can do that, yes.
Yeah, that's a good point. Okay, so we have that one. So item 5, Mr. Tedeschi.
Mr. Tedeschi, or a representative from the Mayor's Office Disability, would you like to proceed with your complaint today with 6 members present, or would you like to request a continuance?
So I'm a little bit unclear on the 6 and how that.
Let me explain it to you. So the way our task force is structured is to find a violation, at least 6 out of the sitting members would have to vote for that violation. In this case, there are only 6. Usually we have a full complement of 11, so even if we're 9 or 10, it's not perfect, but that's doable. So it's 6 out of 6 you need.
Okay, so 5 out of 5 say yay and 1 says nay, then it doesn't pass.
Then it fails, yeah. Okay. So you take the risk of you can go for it and see what happens, or you can continue. You want to go for it?
Yeah.
Okay. All right. So that one's 5 is. So item number 7,
Mr. Petrellis, would you like to proceed, or would you like a request a continuance?
Honestly, I don't know, and thinking out loud, would like to proceed because I've been here for a good 90 minutes or so, and I've been waiting a number of months to have this matter resolved, and even though there is no one here from Supervisor Sheehy's office, that may be a benefit to me to getting 6 votes. Yeah, and I just feel this is really it's wrong to put the burden on me.
Yeah.
To come up with to consider this now in the past 5 minutes and think all the implications here. I need a few more minutes.
Okay,
we can hear from the other people.
We can come back to you. Member Moss?
Just to make sure I understand, but we do have the ability, if we go through a hearing and we feel like, as we're hearing this, that we feel it should be continued because we as a body don't feel prepared to it.
If there's, if the matter is complicated enough and we really feel we need the rest of the absent task force to weigh in, we can have a motion to continue. We can do that too. Okay, so that's 5. 7 is on hold. Item number 8. Mr. Busey, and I apologize if I butchered.
Ask a continuance. Mine's a very complex legal.
Okay, and
basis.
did I pronounce your name correctly?
Bussey.
Bussey. Okay. All right, so that's a continuance as well. Okay, back to you, Ms. Petrelis.
I'm going to take my chances and have it heard today.
Okay, all right. Okay.
Would a member of the task force like to make a motion to continue numbers 8 through 10 to a future agenda?
I'll make that motion.
I'll second.
8 through 11.
8 through 11. Thank you for that correction. Yep.
Member Hinty made the motion. I didn't catch.
Seconded. I did.
Mr. Kanata made the second.
And then we'll take public comment on that motion. Seeing no public comment, take a...
On the motion to continue items 8 through 11 to a future date, Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Not here.
Fisher absent. My apologies. Member Hinsey.
Aye.
Hinsey, aye. Chair Wolf absent. Member Eldon absent. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Acting Chair Hyland.
Aye.
Hyland, aye. The motion passes. Those matters will be continued to a future date. The parties will be informed of that scheduling.
Apologies to those that waited as long as you did.
Next on the agenda is item number 5, file number 17055, complaint filed by Dente Tedeschi against Donna Atkins and the Mayor's Office of Disability for allegedly violating Administrative Code's Sunshine Ordinance Section 67.5 by restricting access to a public meeting. The complaint committee heard the matter on July 24th, determined the task force has jurisdiction, and referred the matter to the task force without a recommendation.
Through the chair, before we
Yes.
get started,
Yes.
just in the interest of full transparency, I do know the members of the staff at MOD through my work. I don't think that that'll bias me in that in this case, but just putting that out there.
Thank you. All right. Did this case come before a subcommittee? And if so, could somebody give me a summary? Member Tesfaye, did this come through your subcommittee?
I believe so.
Can you give us a quick?
Let me get my notes. Sorry.
All right.
Thanks, everyone. So when this came through the complaint committee, we were dealing with a couple of different complaints, but here we are dealing with attendance at a meeting at City Hall. The petitioner had a dog that was used for nonviolent protection, if I recall correctly, and he can clarify or correct that.
Sure. She was a service animal.
So a service animal used for nonviolent protection. Building management was called when he was trying to enter the meeting. He says that the building management, which included law enforcement, had called the Mayor's Office of Disability to receive counsel on whether this dog could come into the meeting without a restraint. In this case, the response to the Mayor's Office of Disability, was that they were not the ones that spoke to the Sheriff's Office on this matter, and that they did not advise on whether this animal could come into the building or would have to stay outside of the building. And so here we're talking about not being allowed to have access to public meetings in that section of the Sunshine Ordinance.
Did we remind me what our recommendation was?
This came to the full task force without a recommendation.
Okay. All right.
Okay. So yeah, hi, my name is Dente Tedeschi. This complaint was regarding the dates were actually incorrect that I gave. This happened on April the 11th, 2017. I came to City Hall to attend a SFMTA board meeting, and I was told that I was not allowed in because my animal was not on my service animal was not on the leash. I first actually when they asked me, they said, what task does your animal provide for you? I answered nonviolent protection and also grounding, but I mainly said nonviolent protection. And they said, they told me to hold. They called the Mayor's Office on Disability, talked to Donna Adkins, whose response was that nonviolent protection is not a task covered under ADA. So therefore, I was not allowed. I was not allowed entry. I sent an email to her, asking why I was being denied entry to, and why I wasn't being afforded the permission or what the law allows me to have in saying nonviolent protection as a task, and she would not discuss the item. She said this conversation was over. So then I went back to email form by emailing her exactly what happened, and I got an email response to her. From her, as you can see on the. From her on April the 17th, saying, "Hello, Denta. Thank you for sending this, Donna." Again, not really addressing what happened, but basically not confirming or denying what I knew had actually happened. This has happened more than once. In different city agencies. This has happened with Project Open Hand, and I was lucky enough by them to actually have an email from them saying that due to consulting with the Mayor's Office on Disability, and their answer to my response of saying nonviolent protection, that they were denying me based on that. Here is, sorry. So under ADA, under
can you move over?
Center that more, please.
Sure.
Yeah,
Sorry.
there you go. Thank you.
What is highlighted? It's on section D, animal under handler's control. A service animal shall be under the control of its handler. A service animal shall have a harness, leash, or other tether unless either the handler is unable because of a disability to use a harness, leash, or tether, or the use of a harness, leash, or tether would interfere with the service animal's safe, effective performance work or task, in which case the service animal must be otherwise under the handler's control. And it gives the example of the three other ways of control, which is voice, signal, or also tether. That is the law. My animal has never been out of control ever. She's never been known to bark or to bite anyone. I have that right, and I'm saying that again. Here's another. Here's another mention of that particular law, saying that the whole purpose of the leash rules is to have your animal under control. Voice control is a method of having your service animal under control. The Mayor's Office on Disability has always referred my animal as a service animal. They've never. Here's another email. Going back to 2015 from Donna Adkins again. Denta Tedessa, person with a disability who has a service animal. So the question is not, I don't have a service animal. I have a service animal. I'm allowed and afforded the rights under that to enjoy the privileges of that. That's it.
Thank you. Is anyone here to talk in support of the petitioner? Seeing none. Is the respondent here, Victor? Yes? Okay.
Good afternoon, Mayors of the Task Force. My name is Donna Adkins. I'm the Programmatic Access Specialist for the Mayor's Office on Disability. On April the 4th, I received a phone call from the building manager at City Hall stating there was a gentleman who had a dog and the dog was wandering away from him, and he was attempting to get through security, and they were calling for technical assistance. I gave the technical assistance, which is that the animal must be under the person's control at all times. Any short of that, the person with the disability can be asked if it's not apparent that the dog is under the person's control. The person with the disability is always allowed into any facility and they may leave the dog outside. Approximately 40 minutes after that phone call, Mr. Tedeschi showed up in our office, very angry, stating that he had been denied entry to City Hall. I went through the two questions that are allowed under Title II of the ADA in terms of service animals, which are the questions that can be asked are you a person with a disability that requires a service animal, and what trained task is what task is the animal trained to do for you? When I asked those questions, he became very angry and said, you are not allowed to ask those questions. Clearly in the law, it says that is one of the questions people can ask if it's not apparent. His response to me was that the task was nonviolent protection. I tried to clarify that a little bit with him, and so basically he said that it was for his safety to have the animal, and I was still trying to clarify that because I'm not really sure how safety is a task under the ADA for a service animal, and I stated to him it sounded more like a pet. At that point, he became really angry. I said, maybe this conversation needs to be over, and that was the last I heard from Mr. Tedeschi, other than the email following. That's all I have.
Thank you. Anybody else in support of the respondent? Yep. Okay.
Good evening, everybody. Can you hear me all right?
Yes.
I'm Nicole Vaughn. I'm the director of the Mayor's Office on Disability. And I would like to say that the question at hand is whether or not what is the access to the public meeting. The position of the Mayor's Office on Disability is we provide technical advice to whatever questions were asked by our city and public colleagues, irrespective of who the question is referring to. We provide technical advice, and then our colleagues can choose to follow it or not. We do not have the capability in a moment like that to make a judgment about whether or not an animal is effectively under control. And in this particular situation, we rely on our Sheriff's Department colleagues for that. That is part of their job. So I feel like as the Mayor's Office on Disability, we provided appropriate advice in this matter.
Thank you. Just point of clarification, and perhaps you can answer this. I don't know if Member Wolf has the same question. Where does the buck stop, with you or with Ms. Atkins on ADA?
So we would defer. Ultimately, we would defer to our city attorney. We provide guidance based on our interpretation of the regulations, but we don't have jurisdiction, any kind of legal jurisdiction. It's interpretation of advice that we then provide to our city colleagues, and so that they can do their job to the best of their ability.
So you're kind of an educational, technical assistant to all departments on ADA.
On Title II of the ADA, correct.
Okay. And Ms. Atkins, what's your function in this again? If you could just restate.
I'm the programmatic access specialist, so our office provides, and particularly myself and another colleague, provide technical assistance around Title II of the ADA to city and county funded program services and facilities, as well as members of the public.
In English? Let me ask you another question. Maybe Member Hinsey could explain that for us better. I'm trying to get an idea around. I understand what you do, and what you do is like a subset of what she does within a particular area. Is that how I'm reading that, or?
Our entire office is well versed on Title II of the ADA, and so anyone that any member of the public or city-funded service or program or facility can call and get technical assistance from our office. There are a couple of us who have sort of a specialization, if you will.
Okay. And Title II, in a quick summary, is?
Title II of the ADA covers state and local government, so anything that has to do with a person with a disability under the umbrella of state and local government.
All right. Thank you.
Sure.
Member Wolf.
Quick question for one of the MOD reps, and I'm not sure which one is best to answer this question. It may have already been answered, but I just want to make this really clear. If a decision is made not to allow someone and their service dog to enter City Hall, is that decision made by the Office of MOD, Building Management, or the County Sheriff?
First of all, the technical assistance provides that the person with the service animal is always welcomed in any service, any city agency or service or program. Even if they're asked to leave the animal elsewhere, they're always welcome to come without the animal. In this particular situation, that technical assistance was given to the building manager, which I believe was then relayed to the sheriff. So that particular decision was, I would assume, was made by the sheriff based on what was happening there.
Great, thank you. If the complainant could approach, please.
And so now I can definitely show you.
I have a question for you, sir.
Yes, sir.
So you showed us a document earlier, and,
Yes.
and it did provide a pathway to maintain your service animal under voice control, but there were a couple points in order to be able to do that. The first of it's actually an either or, but are you unable to hold a leash for your dog due to a physical or other disability?
Yes. Yes.
So you are unable to hold a leash then?
At that time, yes. Yes.
All right.
And, I'm sorry, go ahead. I'm sorry.
And I'm still a little unclear as to what this nonviolent protection means. What training does the service animal? What training has the service animal undergone, and what can you say about that?
I can. So again, this is a direction from the ADA network. If you can see, providing nonviolent protection or rescue work is actually under tasks. So there's two things you can ask me. You can ask me, is my animal a service animal, or is it a pet, or is it a support animal? I'm going to respond to you, she's a service animal. Number two question that you can ask me is, what task does your service animal provide? And I can answer that. Nonviolent protection is a task. And if you need to go further into it, then that's me divulging basically my disability and that particular disability, which the law allows me privacy on.
Sure,
and so
you are free to not answer this question.
Oh no,
but
no.
I believe that I'm allowed to ask it, which is, what, if any, training has the service dog gone through so that they can meet your needs?
The ADA allows me to train my own service animal. Period. There's no special course I have to take. There's no special ADA class I have to go to, or my animal has to be certified. What my animal has to be, though, in order to be a service animal, is to be current on vaccines and also spayed, which I have followed all San Francisco laws. I have, sorry. This isn't the first time that this has happened with the mayor's office on disability. This happened numerous times. This is actually another definition. Again, examples of work or tasks include, but are not limited to, assisting individuals who are blind, who have low vision with navigational or other tasks, alerting individuals who are deaf or hard of hearing to the presence of sounds, providing non-violent protection. It's right there. I don't know how I need to clear that up, or how I need to explain that to everybody, that is a task. ADA is specifically saying that that is a task, and that's what I'm saying.
Okay,
and so based on that, the mayor's office, they're saying now that they're not that they're just there as a quasi assistant.
Okay, let me
just a recommendation kind of.
So
and
some of my colleagues have some questions they want to ask you as well. But let me
just point of clarification.
Can I fill then you can follow up? Is that okay?
I mean, I just wanted to read you the definition of nonviolent protection if it would help you.
Go for it. It doesn't really help me, but go for it.
It just because now I'm curious, but it just says,
Go
for
ahead.
example, maintaining distance between the handler and other people by alerting the handler to the approach of a person from behind, such as by nudge or by a nose nudge or upon the handler's leg. That it's
Okay.
distance between
Anyhow,
people, things like that.
let me
And when
get
somebody
back
comes
to the
your door
question.
knocking, also if somebody knocks on my door, she'll bark, but she won't bite them. Like clearing rooms. For example, if you have a fear of going into a room, you are allowed to have your service animal obviously off leash, go into the room, clear it, come back to you, and that is the task.
Okay, and I understand that you did the training of your dog.
Sure.
I understand that you have a right to privacy around any disabilities.
Sure.
However, you just described two things: clearing a room, and the dog notifies you, or a dog could notify you when knocking. Are those two things that the dog has been trained to assist? Are those two examples things that your dog has been trained to do to assist in your needs?
Yes.
Thank you.
Yes, and it goes on and on. It can it can be also alerting to medication when you need to take medication, when you need to do this or that. Again, here's another email. This is from Project Open Hand.
I'm done with my questions.
Okay, Just 1 second. Mr. Des, I can ask a quick question. One thing I'd be interested in examining here is, it seems to me that you in particular were known to Ms. Atkins, and I'm sorry, what was your name again? Ms. Barn. Okay. That you're known to both of these ADA people in City Hall and other buildings.
Yes.
Did the on-leash, off-leash thing change and maybe caught them by surprise, or were you always a known ADA person with an off-leash service animal, and someone just fell asleep on the watch? There was an MOD that didn't know. There was a sheriff's, a member of the sheriff's department that just didn't know the nuances of ADA, and you suffered as a consequence. That's what I'm trying to determine here.
No, I believe this is a concerted effort by San Francisco City agencies, starting with now what I know is MOD, by Muni, the city attorney's office, housing, even Project Open Hand, like I have here.
Mm-hmm.
They actually specifically say, we have consulted the mayor's office on disability, and based on your response, I'm sorry.
Yeah, I can read it.
Your response was nonviolent protection. Again, I am responding to the number 2 question that they're allowed to ask as nonviolent protection, which now actually before they never even asked that second question. Now all of a sudden, I have the mayor's office on disability responding that my particular answer is not valid, therefore I am not allowed to have food. I am not allowed to have transportation. I am not allowed to have housing. I'm not allowed to even enter City Hall to attend a SFF MTA meeting.
Okay.
And it's basically on that particular nonviolent protection.
Great. That's fine. I think you've satisfied the requirements. I think you've laid it out. I had a question for Miss Atkins and Miss Barnes. If they can both approach. What can you say to convince us that you haven't failed this ADA person?
Well, first of all, I'd like to state that when I received the phone call on April 4th, I didn't know who the client was.
Did you ask?
I did not.
Why not?
It doesn't matter. It doesn't matter.
If he's a known entity, we would not be here. You could have said, "Oh, that's Mr. Tedeschi. Please let him in. He's shown all his paperwork."
With all due respect, the way the law is written, it applies to everyone, and so it doesn't necessarily need to be person specific.
Do you reside in the City Hall?
I do not.
Okay. Does your office reside in City Hall?
It does not.
I know it feels like we reside in City Hall sometimes, but my point is, I don't think you guys did enough in this case, which resulted in him not being able to attend a public meeting. That's my position, and I'd like you to convince me otherwise.
Okay. I would disagree by saying the issue, we do not disagree at all about the nature of the service dog or the nature of the service.
Okay.
The issue that was brought to our attention was that the dog in that particular moment was not demonstrating being under control, voice or otherwise. And so if the dog or anybody is disruptive, the sheriff's department has the jurisdiction to decide that that animal can then be removed for disruption. That was the issue that we were asking.
Okay, and we have no idea we don't have any video evidence, we don't know what disruption allegedly took place.
You need to ask the sheriff's department, but we were basing our advice on a question about what can I do because this animal is not demonstrating being under control.
What did the sheriff's department tell you the animal was doing?
I didn't speak to the sheriff's department. I spoke to the building manager, and apparently she spoke to the sheriff's department, and she said the dog was wandering around, and that he wouldn't tether the animal or have the animal close enough to him to go through security, and so she was calling to find out what technical assistance we would give.
I find that hard to believe. This is a highly trained animal. It's not going to wander around.
So can I just, with all due respect, I don't think that we're here necessarily to talk about whether or not we agree or disagree about Mr. Tedeschi's service animal or nonviolent protection. I believe what we're here to discuss is that whether or not our technical assistance prevented him from showing up at a public meeting. And I would say respectfully,
we're here to discuss a violation of 67.5.
Right. So I would say respectfully that based on the information we gave to the building manager, who then I assume gave to the security, he would have still been able to come to the Muni meeting, even if it meant he had to either A, leash his dog or leave his dog elsewhere.
I'd like to also clarify a few more things about the ADA.
Okay.
So the ADA is silent, as far as we understand, on the nature of training. That is not one of the questions that you can ask.
Okay.
So we have to go on the assumption that the person needs to take responsibility for appropriate voice control of their animal in whatever that form that takes. So that may mean they've gone through extensive formal training, or it may mean that they chose to decide as an individual that your animal is trained enough. But there's no requirement that you must train your animal in order for it to be a service animal.
Yeah, that was made clear to us. Thank you. Member Moss, and then Member Canada.
Is that okay, Member Canada?
Yeah.
Okay, so two things come to mind. First of all, I think we're looking at the wrong section. I think it's 67.13 that is barriers to attendance prohibited, not 60. I mean, 67.5 may be something relevant, but 67.13 is the appropriate section.
Good catch. Okay.
But the thing that the bigger issue here is that I don't think we've got the right respondent here.
I agree.
I think that
I agree with that
I think
too.
that, and I think that this warrants either a refiling of complaint or a motion to continue, because you can't make a complaint against the sheriff's department for blocking. You have to make it against the policy body. I mean, that's the way the ordinance is written. Is that it's no policy body should conduct a meeting. So the policy body, the SFMTA board, could have, I'm not saying they have or haven't, but under this, if this was all, true or whatever, it would be,
well, then, he could have
the
been
policy
there.
body would be violating and not the...
He could have been there to go to 5 meetings that day. So, I mean, would you not maybe, what about the Sheriff's Department or the MOD?
I mean the way that it says, we can't, it says no policy body shall, it doesn't say no government agency shall prevent somebody from doing it. I mean, it's just the way it's written, right?
Okay. Member Canada?
Yeah, I would. That's where I was going. Who's really responsible for this? And I find it hard. If I was in your position and somebody called me and said the animal is wandering, what else did you ask? I mean, I know dogs that the dog could be across the room, and if a person snaps their finger or whatever their command is, that dog is right by their side. So, I'm in my mind, I'm trying to grasp at, number one, how can a conversation from this office, this mayor's office on disability, prevent you from getting in when it was actually the people on the other end? So what did you tell them? The dog has to be under control.
I said yes,
Right.
and effectively under
So
control.
now it's up to my, if I'm the person calling, it's up to my interpretation what under control means. So who really is the responsible party for not letting this gentleman in this meeting? That's
Agreed.
That's what it seems. It seems like it doesn't seem to me like it would be MTA, because they don't even know that this gentleman is trying to come in.
Right.
So-
And we can address that. Member Tesfaye?
Yeah, that was the only comment I was going to make. When I had presented the facts, I had said that it wasn't even clear if the respondent was the person who spoke to, that was communicating directly with the complainant. So that's why we sent this without any kind of recommendation. It was sounded like a game of telephone with a lot of misinterpretation going on, or leaving space for interpretation of a few statements that were said by the mayor's office based on limited facts that they had received.
Just to reiterate our advice, we as Donna said earlier in her, as she was providing the information, we did not advise that Mr. Tedeschi not be able to attend the meeting. We said if the animal is being disruptive, the dog can be removed. That does not necessarily prohibit Mr. Tedeschi from still moving forward to attend the meeting.
Right. But, I mean, based on the description you got, wandering around is not being destructive. And I'm sorry, I have a dog. I would never leave a dog outside in the street while I went into a meeting. Not happening. So that is not an option.
I would just say that
I don't mean to get
that this is where I think our technical assistance, based on what was happening at the time, is where the sheriff's department had to make a decision about, based on foot traffic, based on whatever was happening there, and so it was their decision. But Mr. Highland, I'd like to say one more thing, because you said, why didn't you ask who the client was? Our office takes a lot of complaints from people with disabilities, most of whom don't identify as people with disabilities, and so we very rarely ask who was the person, because that would be a violation of their rights.
I understand that, but I'm getting a sense here that there was a history that you've dealt with Mr. Tedeschi in the past. You've granted him access based on his off-leash service animal, based on the letters we saw. So this is a known entity. This is not just, let's read out of the book, oh, here's your advice, sheriff on duty. You guys kind of failed here. I'm sorry. I don't think you helped this gentleman out, and he missed the meeting. Member Wolf, back to you.
All right. Based on the fact that what I'm hearing across the dais is that the people that are here as the respondent are really in an advisory role and not actually in the place to stop someone from getting to the meeting in the first place. It seems like there's a disconnect as to whether the MTA makes sense. I guess that was your suggestion, or the sheriff. I don't know what our best process for moving forward with this case against the right complainant is, but I'm sensing a strong consensus that the current complainant or the current respondent is not in the room now. And so I'm just looking for how to move this along and bring back the right respondent to more properly handle this.
Mr. Tedeschi, would you like to? I've given the other side quite a long time.
So, again, this email on April 17th, again, from Project Open Hand, this is the one time that I could actually get someone to actually admit on email that my answer, that nonviolent protection, was that task, was that second question that you can ask me, and therefore not allow me to get services. And exactly what they said. They said that they actually called the MOD, because I'm the one telling City Hall, call MOD. They know me. And you asked them about that number 2 question that I'm answering to you as nonviolent protection. And when they called them, specifically saying that I was the one who actually told them, I told the sheriff's deputies, and I told Lori Mazzola to actually call MOD.
Right.
They knew it was me. Number three, this is the email I actually sent to Lori Mazzola again, trying to get her to basically tell say the truth. And this is the answer that she gives me. She gives me, Dear Mr. Tedesco, I will not confirm or speak to any of the assertions in your emails other than to say that it's true. Number one, I contacted and spoke with Donna Atkins from the Mayor's Office on Disability. Number two, I made the decision to prohibit the entry of your entirely unleashed dog into City Hall based on the guidelines for service animals that Miss Atkins provided me. Number three, you were shouting and extremely agitated and hostile at that time. Nowhere in that email does she say that my service animal was roaming around, barking, or anything. Wouldn't it make sense that she would actually say it in the email? Yep. This is the building manager that actually called Donna Atkins based on my number two response, and this is what I'm talking about. And even in this email, she was unable to actually confirm what I was trying. What she and I know was that second answer to my task question, which was nonviolent protection.
Okay, all right.
Sorry.
Through the chair.
DCA Kohler? Yeah.
It seems like you're sort of getting into rebuttals without.
Right.
Yeah. So.
But we may end up continuing this or doing something else with it anyway, so we're trying to work out what to do with this. But
point of order.
One second, Victor. I was going to ask you. Okay, point of order.
It's what department is that before that goes away?
Building services manager.
They
are the building service manager. They're in the basement of this building right here.
I know where their office is located, but it's from a departmental level.
Oh, I don't know.
Anyone?
Who's that report?
Building management is under city administrator.
Okay.
But I'm not sure. They may be independent as the building management.
Great, thanks.
Okay. I think at the very least, this person should be, especially with this email, and then the other one you showed, open. Maybe those are the people that should be included in your complaint, and because.
But it's based on they're making their entire judgment based on the call to MOD, and I've had this even in my housing. Actually, right now I'm in the process of being evicted. Believe it or not, incredibly out of the blue, because they called MOD and MOD's response saying that basically you have to have your animal leashed at all times. Period. That's the law in San Francisco. No, that is not the law. That's not federal law. Federal law allows you to have your service animal, if you have a service animal, off leash, as long as if it's for your safety or for your animal safety, you are allowed to have your service animal off leash as long as it's under control. That's the main thing about leashes.
I don't know if this task force should be addressing ADA laws.
What we should be addressing is just purely the fact that he was prevented from attending a meeting, correct? Yeah. And as Member Moss said, Section 67.13, was it?
Yes.
Yeah, through the chair, that's really what this should be limited to. I understand you need to address their, whether or not there was a justification for the denial of access, but at the end of the day, the complainant has a right to name whoever he wants as a respondent, and if he chose to name, the agency that provided provided advice as far as what sort of service animals were allowed into City Hall to attend a meeting.
No,
he's got the right. He's got the right to name them as a respondent.
No,
there's a degree of separation between the advice that they provide and then how the responsible party determines they want to interpret it.
Right.
But that's his prerogative if he wants to name them.
Right. No,
But I think we should stop focusing so much as what the animal was doing at the time and this and that, and just determine whether or not, based on the advice that they gave, was it an unjust denial to City Hall to attend a meeting.
Right. And I think what we're trying to do sometimes for people that come before us and are not used to how the mechanics of you should hire Mr. Hartz. That would have been a very clean case. He could have put it together for you, but. I don't think you should. I think it's just a joke. It's okay, man. But what I'm trying to do is repackage this
Okay.
So we get the right code violation in here.
Okay.
We add parties, responsible parties, and then get the whole thing together. Now, whether we can do it all tonight, I don't know. We might have to.
Okay.
But the fact that you have other issues going on with MOD, I am kind of tempted to try and move this forward and at least get you something.
Previous actually to this particular incident, I was allowed in after explaining the law to sheriff's deputies with no problem.
This evening?
No, prior to April the 11th.
Okay.
I was allowed in without a leash, no problem, because I explained it. They saw. She's actually also trained in grounding. So what the animal does when they ground you is they actually stay in one spot. So it's completely opposite to running around. And so nonviolent protection and grounding are tasks under ADA. I just would like the MOD to appreciate that and to respect that and to not basically answer that is not those are not tasks.
Understood.
And then I'm always at the end of whatever it is, if it's food, if it's transportation, if it's housing.
Got it. All right, thank you. So, members of the task force, I sense there's some urgency here to try and repackage this correctly and move it forward for this petitioner. Victor, would you have any advice on if and how we could do that? Am I making sense? In other words, let's get the right, if we get the right chapter of the code in there, and then we can determine if we want to add. Problem is, if we add other respondents,
we should probably to settle this complaint against MOD separately, and then the complainant can file a separate complaint against another agency.
Okay. Yeah. Member Tesfaye.
Where is your dog now?
She's at the house because I'm not allowed into City Hall. I mean, it's really sad. I mean, I was threatened. I was threatened with arrest, and so after that, I'm not gonna,
Yeah. Okay. So clearly, there's some education that's not happening from your two bodies to the people that run this building. I mean, that's clear as day. So, Member Moss, what was that code you recommended?
6713 was the one for barriers to attendance being prohibited.
67.3?
67.13. 6713.
Okay.
Oh, okay.
So, I think the task force is leaning towards a violation of that code.
We need a rebuttals, though.
Yeah, I'm just getting to that, and so let's get to rebuttals so you guys know where we stand. Remember, Mr. Tedeschi, you would have respondents. Respondents first. You have 3 minutes for rebuttals. You're just wrapping up your case. And we're leaning towards a violation. We haven't made a motion yet, but we're leaning towards a violation of 671.3, which is barriers to entry for a public meeting. And you can present your rebuttals for that.
I would just, urge the task force to take a look at the what happened on the date, which is actually April the 4th and not April the 11th. I'm not sure what we're talking about in terms of April the 11th. But in terms of our office giving technical assistance in a general way and how the Sheriff's Department applied that information based on how they felt they needed to do their job. At no point during that technical assistance did we say he wasn't allowed to attend a meeting by SFMTA. The other thing I'd like to say is I'm not really sure about the Project Open Hand issue and, quite frankly, the housing issue. If I'm being named as the respondent, I am unclear and unaware about either of those. And I will say that even if our office took a complaint around housing, it doesn't fall under the ADA. It's a Fair Housing Act. Under federal law, it would go under the Fair Housing Act.
I concur with that. And I would add that it is not only is it not our practice to ask questions about who the the sheriff's department in this case, or the building manager, is working with. If we did that, we would have larger issues, in my opinion, around violations of privacy. Aside from that, though, I also find it hard to believe that we would make an assumption based on the number of calls that we get on a daily basis about entrance of service and support animals, that we should be able to assume whether or not a particular person is or is not Mr. Tedeschi, and then should make an exception in that case. Where this lies, in my opinion, is we provided technical assistance, and that technical assistance is taken case by case. On a particular day, if the animal was not demonstrating being under control, then that animal would be recommended that they not be permitted to enter the space. On a different day, if the animal is demonstrating being under control, it could be perfectly fine. So just to clarify that really the discretion is case by case at the discretion of the person who is handling security for City Hall.
Okay, Mr. Tedeschi, you have 3 minutes to do your rebuttals.
Yeah.
Yep.
Again, I don't know how to make it clear that we are well known. My white pit bull, Rosie, is known because of SFMTA issues back in October of 2016. It was on the news. It was for them. At that time, the cable car operators were denying us boarding privileges because he was afraid of my service animal. And my service animal in the video, you can look it up on Google, she's just laying on top of my lap, just not even moving. The cops are in my face, so we're well known to MOD. MOD has said, again, like, this is the email on April 17th, again, based on that second question. Let me be very, very clear. Nonviolent protection, and my answer to that number 2 question of nonviolent protection was the grounds of denying me entry. I specifically called out the MOD for sheriff's officers and for Miss Mazzola, the building manager at the time, to call and say and to get confirmation that nonviolent protection was indeed a task. She did that. They responded, no, it wasn't. I was denied access. Simple as that. There's no ifs, ands, or buts. I then went to her. Again, this is an email from her. If my animal, as MOD is stating very, very unfairly and factually wrong right now, that my animal was out of control, she would have mentioned it in her email. Nowhere does it say I was the one who was out of control, not my animal, as you can clearly see on the email. And yeah, I mean, I was denied access based on their response. And again, I've tried to get Ms. Mazzola to actually say on the record that it was because of my number 2 question that I answered nonviolent protection. She wouldn't. She was very cagey about it. Who wasn't cagey about it was Serena from Project Open Hand, who actually exactly said, based on your response, that nonviolent protection was a task. And our consultation with the mayor's office on disability, we are denying you. We're denying you services. I was denied services there. I have been denied services, transportation services. I've been denied housing. I understand that there might be separate, but anyway, that's the truth.
Okay, thank you.
Okay.
All right, Member Mas.
I just want to point out that having now looked this up, there is a picture in an SF Examiner of the petitioner testifying at an SFMTA committee in November 1st, 2016, with his animal at his feet. So he has come in and done public comment before. So I'm inclined not. I mean, the motion I would consider making is not to find a violation, but to send this to EOTC to see if a resolution can be found, because it seems too complicated to me within the ordinance. Because the ordinance refers to a policy body, and MOD is not a policy body in the sense that that we're talking about here in terms of meetings. SMTA board would be the meeting, but SMTA is not here, nor were they involved in barring him. So maybe there's a way to sort this out through a committee process.
Okay. Member Wolf?
First off, the way I read it, I have no idea whether or not the advice given by the Mayor's Office of Disability was appropriate. I'm not going to step into that. The paper we have shows that the actual decision, based on the consult with MOD, was made by Building Services. City Hall Building Management is apparently the actual department when you look it up. The fact that he's been admitted to an MTA meeting in the past without any issues seems to indicate that MTA is not the issue, the body that prevented him from appearing at the meeting. And so, to me, the only reasonable place to point this is the person who claimed to make the decision, City Hall Building Management. And obviously, the MOD may be useful as a reference in that conversation, and to whatever extent their advice was problematic, that needs to be resolved. But when it comes to an entity stepping in to prevent him from attending the meeting, the only department I can look to is City Hall Building Management, and I can't move forward with anything unless it's against them, and they're not here today.
Okay. Anybody else?
Do we have a motion on the floor?
We don't yet. We're having trouble pinning it on anybody. That's the issue. Mr. Frank, Member Canada?
I think the best thing we can do here is try to not have this happen in the future, right? Educate the departments, have the Mayor's Office of Disability maybe send out a memo saying that nonviolent protection is an ADA qualified or certified task, and then deal with Building Services as to why they did. I mean, if the question, it sounds to me, my understanding is that Laurie Mazzola did not stop the complainant from going in because he said the task was nonviolent protection. It sounds to me like she stopped him from going in because she thought the dog was not under control.
Correct.
Well, okay. So, and we're hearing differences from both sides. So,
DC Acola, is looking back at 675, which is how this complaint was framed in the first place. It's pretty general. All it just says is all meetings of any policy body shall be open and public and governed by the provisions of the Brown Act. I don't think there's anywhere in there that this would fit.
Well, I think complainant's making the argument that it wasn't open to all members of the public in this instance.
Right.
But,
So
I mean, do you have a close enough connection to say that advice that this respondent gave to a third party that then interpreted that advice in a way to prevent him from attending that?
Actually, third
Can you
party.
pin that on them?
Third party and then fourth party.
Yeah.
Yeah.
The cleanest way you go through this one is find no violation here and instruct the complainant to bring a similar complaint against the party that you've got the stronger case against.
Okay. Thank you.
So I would be willing to make a motion to refer this to a committee. I just if I want to make that motion, I would say I would want to know from Committee Chair Wolf and Committee Chair Canada which committee, the two they would prefer I make the motion on. You don't have to support the motion, I guess, but I want to know if either committee.
through the chair, I wouldn't know how to start dealing with this from the EOTC side. I feel that there's an EOTC of ADA issues here, but that's not what my committee's for.
Right.
Yeah. And what's...
I mean, I guess what I'm saying is that a committee could hold a hearing in which we get all the parties who are involved with this, and we just have a discussion of what the issues are and how a protocol can be ironed out, since there seems to be a problem that needs to be addressed, but I don't know if the problem will be solved by a vote on a violation, because, I mean, looking at the members here and how we're torn, I don't see a vote resulting in a violation.
Let me ask Mr. Tedeschi something. You see where we're struggling with this?
Yeah.
Let me just ask my question. So I think what I'd like you to do is connect with Victor about how this should be framed, about the parties that should be included, the correct, provisions of the law that you can quote and represent it to us. Now, that might take 2-3 months for it to come back before us.
But the mayor's office on disability is the point. Is
all roads lead to there.
All roads lead,
including
they
other
go.
departments.
All city agencies go to them for advice, and if they're giving the wrong advice, how can I?
Mr. Chairman, I don't think that we can advise on policies of other bodies. That's at a higher level than the task force. The policies implemented by the Mayor's Office of Disability, we really don't have authority over that.
So who do they report to, the mayor?
I would ask them.
City administrator.
City administrator. I mean, this is an important issue. People are being prevented attending meetings, right? So
yes, it's a policy issue that's not under 67, Chapter 67 of the Administrative Code. That's just my brief.
Well, it is under 6713.
For a specific instance, but
so we have to find a policy body that this boils up to, right?
And I've also had other emails to Miss. I'm sorry, to the head of MOD, actually, asking for a on the record, kind of.
Stop. Hold on. We got to take. If you leave, we have to stop, since we lose quorum. Can you wait 2 more minutes?
Sorry.
Okay, so Mr. Tedeschi, I think it's in your interest to rephrase this.
Okay.
And get it right.
Okay.
Because if you don't get it right and it fails, it's very hard to
it keeps on happening. Okay.
to build on that. Okay. And I know that might mean taking 2-3 months to come back. In our queue, but I think if we send it to a subcommittee, we can keep it.
I just have the question myself in that. Who has authority to tell MOD to change their advice that they're giving to
it's the very
other
first,
departments?
It's the same question I asked at the beginning. Where does the buck stop on this?
The chair?
Yes.
It doesn't have to be intersecting what MOD's advice was. If it goes directly to either whoever the policy body that oversees building management, or we decide that building management counts as a policy body somehow, then they're the ones making the decision. It doesn't matter about whether the advice, whatever, we can go directly to who made the decision.
Yes, I understand that, but I believe that Mr. Tedeschi is stating that the advice provided by MOD is causing other situations.
I'm actually being evicted.
Hold on, now we already heard that. No, so all roads are leading to MOD, and
it probably should be two separate issues, one on the violation, and then maybe another hearing on the advice they are providing, but I don't think we should be the body that gets involved in the advice that they are actually providing to bodies on ADA issues.
So the city administrator, who does that report to? Ultimately, the mayor, or board of supervisors, or. And
I don't know if there's some state organization that can make a judgment on ADA advice provided or anything like that. It's just beyond 67, I believe.
Okay. All right. Member Moss, and then we're gonna.
I'll move to find no violation.
Second.
Okay. Public comment on the motion.
Ray Hart's Director, San Francisco, Open Government. Wrong. Was he denied access to the meeting? Yes. Was it based on the advice given by the mayor's office? Yes, they admitted that. They basically said they had no question that it is a service animal and that he is entitled to be in. Now, there's a part of the civil code where juries are given instructions that if one party can present better evidence but they fail to do so, you can distrust the evidence they do present. The mayor's office could have had either the building manager or the sheriff's deputy that was there that night here and explained exactly why they decided this animal was out of control. They failed to do that. They somehow put it on Mr. Tedeschi to prove that it wasn't out of control. And that's not the way the ADA works. I'm really surprised that anybody from the mayor's office would come here and try to defend the denial of services or access to a disabled person who had a legitimate service animal, and they're trying to defend it. And they're not even doing a very good job because, as I said, they could have either of the people who were in the actual room who made the decision based on their advice come here and tell you exactly what happened. But they didn't do that, did they? And I have to question whether or not that was because they couldn't get either one of them to come here and say publicly in front of you that the animal was out of control or give any example as to why it was. He was denied access to the meeting. He is a disabled person. He is identified, and the city mayor's office on disability has not denied that he is disabled or denied that that is a service animal or that he was denied access to that meeting based on the fact that they said, you have a choice. You can either have your service animal and not go to the meeting, or you can not have your service animal. Now, I don't know what they're smoking over there, but the bottom line is we have a lot of vets that are coming back from Iran and Iraq who have PTSD, who have service animals, and nobody under the Americans with Disabilities Act has to justify having the service animal and being allowed access to a public building. They have to prove that they were justified in denying the access, and they have not done that. They gave advice which resulted in him being denied access. They gave advice which resulted in the law being violated. There should be a violation against them, and if he wants to go after somebody else later, that's up to him. But that's not your choice to make. Did they violate the law? Yes, they did. I don't think the facts can be denied. They denied him access. His service animal was not allowed into the building, and that is a violation of the ordinance. Who did it is kind of irrelevant. It's the policy body is responsible for ensuring that the laws are followed, and if their building manager or the sheriff's deputy that they have operating for them, they were acting as that body's agent. And therefore, anything they did was on behalf of that policy body, whether they referenced them or not. He was denied access. His rights were violated under the ordinance.
Any other public comment on this motion? Okay, let's have a question.
Yeah, I have a question.
Okay, go ahead.
No violation means that we're finding that the respondent has committed no violation, not that the incident has no violation, correct?
We were finding that the mayor's office on disability did not violate the sunshine.
Right, so it's just about the respondent, not the incident if someone else did.
That is correct.
Great, thanks.
And just to clarify, if one person on this committee votes no on this, we're back to square one.
Right, and I'm going to propose separate motions after this vote. So I have other things I'm lining up.
Okay.
Yeah. So let's take a roll call on this one.
On the motion, Member Eldon absent. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Member Tesfa. Aye. Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
No.
Kanata, no. Member Fisher, absent. Member Hinsey.
This is no violation for MOD, right? Correct?
Yes.
Aye.
Hinsey, aye. Chair Wolf, absent. Vice Chair Hyland.
No.
Hyland, no. The motion fails.
I'd like to propose two new motions. I'm going to do them separately. The first one is violation of 67.13 to MOD acting on behalf of MTA. That's the first motion. The second motion is a violation of 6721.E for not bringing knowledgeable people that were involved that night to this hearing, and that's a separate motion.
So we need a second.
Second. So they're two separate motions. I want to separate them. So,
is there a second on the violation of 67.13?
Second.
Member Kanata, second. Is there a second on a violation of 67.21E?
May I make a remark about that?
Sure.
So again, 6721E only refers to records complaints. It doesn't refer to open meetings rules.
Shouldn't we only have one motion on the floor at a time anyhow?
6721E is failure to bring a responsible or knowledgeable person.
Under 67.21, which is process for gaining access to public records.
Okay. We've got a.
We don't have the ordinance has a flaw in that it doesn't apply the same thing for open
we're in
meetings.
a short recess at this time.
We're in a emergency timeout.
Barely have
back on the record?
Yeah, do that.
Yep.
Yeah. Okay, we're back on the record.
I believe there's on the second motion of finding a violation of 67.21E1E for failure to provide a knowledgeable representative. The motion was made by Vice Chair Hyland. We do not have a second yet at this time.
I'm going to withdraw that motion because as I've been informed by my learned colleagues, it refers only to records. So there's only one motion on the floor that's been seconded. Public comment on that motion.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. We've talked endlessly about the fact that the Ethics Commission has never, ever enforced one of your rulings. But they serve a purpose. They put a public record in place that says that the Mayor's Office on Disability is advising people in such a way that it results in people being denied access to public meetings. And that is unacceptable. It is totally unacceptable from an ADA standpoint, from federal law, from state law, any way you want to look at it, it's wrong. Mr. Tedeschi was denied access to the building based on their advice. And I understand why he filed it against them, because if they've advised other people and it's resulted in similar problems or concurrent problems or related problems, I could understand why he would want to go after the office that is advising these people. And they could have brought somebody here who said, yes, his dog was running all over the place, it was barking and snapping, but they didn't, did they? And I think that's probably because, honestly, they couldn't bring somebody who was willing to make that kind of a statement. And so they want you to rely on his facts, because he was there, versus their hearsay. And that's really all they have, is hearsay. They have no facts to support their argument. I talked to people. I don't really know who I talked to. I don't know what they did. It's not our fault they took my advice and used it the bad way. Well, try going into a court where the city attorney advises somebody to do something and then tell the judge, well, hey, we're not guilty because the city attorney said we could do it, and it's not our fault we relied on bad advice. They relied on bad advice. They got the bad advice from the city's office of the mayor's office on disability. And they should be found in violation because it was their action that resulted in Mr. Tedeschi being denied access to that meeting. And he was. There's no argument about that. He was denied access to the meeting. He was only given a choice. You can go in without your service animal or not. And he made the choice that most or many disabled people, I think, would make, would be, if I can't have my animal, then I really don't feel comfortable going to the meeting. And therefore, you're kind of coercing the person into leaving. And that's really what was done. He was coerced. Basically put in a position, either you leave your animal outside or you go to the meeting. Your choice. But that's a false choice. It is a choice he should never have been asked to make. But he was, wasn't he? And it was based on their advice to those people. And they could have said, I'm going to say one more. The Civil Code says that if you get parties who can provide information and they don't provide the good information, you can distrust what they did. And they didn't have anybody here. I distrust everything they say.
Thank you.
Hello, Michael Petrellis again. I've been educated listening to this debate that's been going on, and I can't speak on behalf of any other disabled people with dogs, but I think that if they were able to watch this debate along with everyone inside the sheriff's office, they'd all get an education. And I got to speak again for putting these meetings on city government TV. Thank you.
Thank you. All right. Have a roll call vote.
Motion is to find a violation of 67.3. On that motion.
Sorry, 67.13.
67.13, yes. On that motion, Member Eldon absent. Member Josh Wolf.
No.
Wolf, no. Copra absent. Member Tesfa.
No.
Tesfa, no. Member Moss.
No.
Moss, no. Member Kanata.
Aye.
Kanata, aye. Member Fisher. Absent. Member Hinsey.
No.
Hinsey, no. Chair Wolf, absent. Acting Chair Highland.
Aye.
Highland, aye. The motion fails.
Okay. So, Mr. Tedeschi, if you'd like to approach. I think you learned a lot here tonight about how
I
our
did.
process works, and
I did.
we had trouble pinning this.
Sure.
Member Wolf found something on the internet.
Yeah, so through the chair, I don't know whether this is going to help you, and I haven't been able to exactly figure out who serves on it, but I was trying to figure out like who oversees the Mayor Office of Disability, and there is the Mayor's Disability Council, although it looks like it's staffed by the Mayor's Office of Disability, so it may not actually be a way to oversee the organization, but at least it's a forum to bring this issue to light. You could call the media, get as many people there to really have a conversation there, and maybe what comes out of that conversation can help guide our future deliberations.
Okay. Okay.
And, you know, what does the task force think about sending this to EOTC just to, you know, have a conversation between MOD?
I don't think that makes any sense as chair of EOTC.
And my question is, could we send this to any committees, even if because we haven't found any violations?
I think we can still.
Actually, this matter, no violation was found and the matter is closed. You can ask one of the committees to conduct a hearing if you'd like.
Okay. All right. And which committee would be, if we were to do that?
Not only that, what would the hearing be about? I mean, I don't think we have, as Member Wolf keeps saying, we don't have any authority over how the Mayor's Office of Disability interprets ADA.
Yeah, I think first of all we need to find a chain of command here, and hopefully Mr. Tedeschi can do that with Victor, whether it's MOD to City Administrator to the Mayor, whatever that is. And I think once you refile with that correct chain of command with 67.13, which I think is the correct code.
And I believe that would be a violation against the City Hall building management.
Yes, who then report to the mayor.
Okay.
Then it comes back before us. This case will be referenced probably. You know, we'll remember this, and it might be 2-3 months before we get this back in front of us again.
No, I have another. I have another item on the
those
October.
are different issues, though.
But it kind of all relates with MOD. There's a whole circle.
Every department is taken separately.
Okay.
Is that already? That hasn't been agendized though
No,
yet.
they're tentatively scheduled for next month, but that may get changed due to the continuances.
Okay, and let's double check the language on you know who.
They're different issues, completely different issues.
Okay. All right.
All right, thank you for your time.
As far as we can help you right now. All right.
Thank you.
Thank you. Thank you, Ms. Atkins.
Next on the agenda, item number 7, file number 17071, complaint filed by Michael Trellis against Supervisor Jeff Sheehy, Board of Supervisors, for allegedly violating Administrative Code Section 67.25 by failing to respond to an IDR in a timely and a complete manner.
And we found jurisdiction for this in subcommittee?
Yes.
And someone like to give a summary? Which subcommittee did this come out of?
Complaints.
Okay.
Correct? Yeah.
Yes.
So in this case, Mr. Petralis is bringing this complaint about personal attacks that were occurring. Mr. Barnes had stated that after initial review of the requested records, the Office of the City Attorney had been consulted to determine if Supervisor Sheehy's records regarding his membership on a past state agency should also be disclosed. Mr. Barnes had stated that it was determined that only the records, determined I think by the City Attorney, that only the records related to Supervisor Sheehy's time with the actual Board of Supervisors would be disclosed, not records of his time in prior other positions. in this, when we were looking at this case, we spent a lot of time looking at section 67.25A. And though we did not provide a specific recommendation, we thought it would be great for the full task force to be able to hear this because there were some complicated issues about past service and whether that would also be subject to a request for public records.
Point of clarification. Are these past positions with San Francisco government?
I don't believe so. I think it was a state position.
Okay.
And I'm sure that Mr. Petralis will be able to provide more specific details about what occurred in his case.
Okay. Thank you. Mr. Petralis.
Hi, Michael Petralis again. The larger context here is that I've got a writing gig with the Castro Courier newspaper, and the editor had decided that what I'd be writing about for the July issue was Supervisor Sheehy responding to constituents and public records requests. So there was a real deadline imposed on me by the editor to get his calendar so that we could look at how he was spending his time since he had been appointed in January. And I was really hopeful after getting the first response on June 15th, I'm looking at page P177 of the big catalog here. This confirmation email came from Justin Jones at Sheehy's office, and he ended the email saying, "We anticipate responding to your request by June 23rd. And then on June 23rd, 2 minutes before 5 p.m., I got an email from Bill Barnes, the chief of staff for Sheehy, saying that they needed to invoke an extension of not more than 14 days due to the need to consult with another department or agency. I believe the supervisor's office and his staff had a duty to consult with this unnamed other party when I made the request. They should not have waited this long. I think they should have also said why they needed to consult with the other department. And lastly, they should have named that department, which they didn't do. I eventually did get the records, and it was past the deadline for what I had to turn in to the Castro Courier. And I see it's Nicholas, right? You're Nicholas? That's Nicholas, right. Asks on page P180 questions that might assist in determining facts, of course, should the complainant eventually receive the requested records. I did. But more importantly, asks, can the supervisor elaborate as to why 2 extensions were necessary in order to respond to this request? That is very important to me, and that's why I'm here tonight for a few hours pursuing this. And I think that it's very important that there is clarification for the supervisors and their staffs about when they get these kind of requests. If they do need to consult with an outside agency, they start that process as soon as they get the request.
Thank you. Is anybody here to provide evidence in support of Mr. Petralis?
Excuse me. Ray Hartz, Director, San Francisco Open Government. And I have a feeling that we may be dealing with the, I understand Mr. Petralis's point, but I think you also need to consider Section 6724, public information that must be disclosed. Because if you look at Section C, personnel information, none of the following shall be exempt from disclosure under Government Code 6254, Subdivision C, or any other provision of California law where disclosure is not forbidden. And you go down there, it says sex, age, and ethnic group, years of graduate and undergraduate study, years of employment in the private or public sector, whether currently employed in the same position in another public agency, other non-identifying particulars as to experience, credentials, aptitudes, training, or education entered into, attached to a standard employment application form for the position. Now, my understanding was he was asking questions about Commissioner Shee's credentials, personnel information. And all of that information is here in the ordinance very clearly stated it must be disclosed. And I heard nothing, and of course we don't even have anybody here from the other side. I heard nothing to justify withholding the information, but they did. And it resulted in him not being able to publish his article. So the bottom line is they violated the ordinance, and whether you want to find it 6724 based on the substance that they withheld, or on Mr. Petrellis' arguments about the immediacy of the response and the fact that it resulted in him not being able to, freedom of the press, his not being able to publish an article relating to city government. What's the purpose of this law? This law, in my mind, is to make sure that people who have a passion about government and government being run properly have some tools to use to force these folks to do what the law says they're supposed to do. I mean, look at all the orders of determination I have. The bottom line is, you make a request of a government agency that they are by law required to respond to in a certain way, and they don't. That's what we have here. He made a request of Supervisor Sheehy that he failed to respond, and he also didn't send anybody to this hearing. And to me, I'll be honest with you, whenever they don't send anybody, it's usually a mark of the fact they don't want to talk. Why did Mark Farrell never send anybody either to the task force or to the Ethics Commission? Because he knew he was guilty. You can't force somebody to testify against himself, but he sure isn't going to show up and make himself a target for any questions that somebody might have. He was denied access to the information. It sounds to me like the information he was requesting is very clearly covered under the personnel information that must be disclosed part of the ordinance. And the delay was not explained in any way. And I don't see anywhere in the ordinance where you can ask for 2 extensions. I see if it's an immediate disclosure request, you have till the end of the following business day to ask for the extension, and then you have 10 days after that. End of story.
Thank you. Seeing no one else in the room, the respondent is also not here.
The respondent is not present.
Not present. And no one in support of the respondent since no one else is here. This case is before the task force member, Canada.
Mr. Petrellis, I just heard about personnel records, but I'm looking at what I think is your IDR on page 177, and you're asking for an electronic copy of his calendar from January 1 to January 4th. January 1 to June 14th of this year.
Right.
That's your request?
Right.
Okay. When was he appointed supervisor?
I'm going to say January 11th.
Okay.
But don't quote me on the date. It was sometime in January.
Thank you. I see no reason why the calendar from the time if other departments or other agencies had to be brought into this, it was only from January 1 to the date he was appointed supervisor. So I don't see any reason why the calendar from when he was appointed supervisor to June 14th wasn't made available immediately.
And then I think I was in the subcommittee that heard this, and Mr. Barnes did show up to the subcommittee meeting and did answer some questions. And I think our new practice is that we do require attendance in the subcommittee, but not necessarily the full task force. So they satisfied that.
I think our standard is that they must attend both.
Oh, it is? Okay.
Yes.
Maybe that hasn't adopted yet. So let's say, for sake of argument, that it was January 11th that he took office. Was there argument that we have to check on January 1 to January 11, and therefore we're invoking extension? Was that the basis of...
My recollection of Barnes's verbal presentation was that because Supervisor Sheehy is on a state panel about stem cell research, that they needed to check with the city attorney about whether that information could be disclosed. I mean, the information that he was a member of that state body and that he attended at least one of the meetings. My recollection from reading the calendar was about 94 pages, and it was very informative, let me tell you. He attended at least one. There may have been a second stem cell research meeting.
Okay. And after they determined that they could release it, they did release that information to you? That's correct?
Yes, they did.
Okay. So you're
But that was only verbally conveyed once we got here, again showing the importance of the task force.
Right. And so basically you just want to note for the record that the response was not timely.
Correct.
Okay. see no argument with that. Anybody like to make a motion?
We need rebuttals first.
Okay.
Although I don't know who he's rebutting, but
Do you have anything else to say, Mr. Petralis?
Yeah, you've got 3 minutes.
All right.
Okay, I'm going to take that as a no.
No rebuttal from Petralis.
Victor?
Is there a motion?
Is there a motion? No.
I'll move to make to find violation for 6725.
For timeliness.
Timeliness.
Is that A? Yeah.
We have.
I'd like to also add to that motion, I don't have the sending.
721E?
Is 21E adequate?
For failure to send a representative?
Yes, exactly.
Can we split those motions?
Does the maker accept the friendly amendment?
Well, I only moved to find 6725, so.
Right, so I've made an amendment. You can deny it, and then we're still in one of a second.
Suggestion to add 6721E.
Sure, that's good.
I believe the motion made by Member Kanata as amended.
But we have another.
We're going
I'm just saying we only have 6 members here, and so I would say it was it's in the interest of to split it.
All right. Split the vote on that.
I don't think we should split the vote on it. I think we should just vote again if it doesn't pass.
The motion made by Member Kanata is to find a violation of 67.20 on E for failure to send a representative to the meeting, and 67.2 for failing to respond to the immediate disclosure request in a timely manner.
0.25.
Is there a second?
Can I second that? Or,
yes.
Okay, I second.
Public comment?
There was no public.
On the motion.
There's Ray.
Oh, that's right.
Well, no, Ray gave testimony.
He gave testimony.
Okay.
Seeing no public, there is no public comment.
On the motion, Member Eldon absent. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
No.
Moss, no. Member Kanata.
Aye.
Kanata, aye. Member Fisher. Absent. Member Hinsey.
Aye.
Hinsey, aye. Chair Wolf, absent. Acting Chair Highland.
No.
Highland, no. Are there any additional motions?
Motion 67.25 for timeliness. And that's it.
67.
Second.
5.
Seeing no public comment. Roll call.
On that motion, Eldon absent. Member Josh Wolf.
No.
Wolf, no. Member Copra. Absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Fisher, absent. Member Hinsey.
Aye.
Hinsey, aye. Chair Wolf, absent. Vice Chair Highland.
Aye.
Highland, aye. The motion fails.
Just want to throw out the task force. The reason I voted against the first motion is they did send somebody knowledgeable. He was very thorough. And because he showed up and because we had the meeting, we kind of untangled all this. They then announced they're not going to show up to the second meeting, which, you know, you can find a violation if you like, but if you're in the subcommittee, you probably wouldn't have brought that one up, I think.
Can I explain why I munged the whole thing up in response to that, though?
Could I just add on, since before we move on to the second vote explanation, the reason I voted against it is because, unfortunately, another weakness in this failure to send someone to respond only applies to records when they fail to send somebody to explain why records were withheld. And I don't believe that we have a case of records being withheld here. We have records of them
being late,
slow, but not being withheld.
Also true by the letter of the law.
So I would argue that by withholding them at first, they were withheld even though they eventually were turned over. So that still would apply for the representative. We went through this process about whether or not they needed to send a representative to the committee level and the hearing itself, and like it itself was a problematic process. But basically, I can't vote on anything that doesn't involve not sending an adequate body because it's all hearsay about what the other side is saying, and that just doesn't make sense to me for not the main hearing.
Member Kanata?
I think this just goes to exemplify the fact that we really, as a body, have to take up the issue of what to do when we don't have X number of people here,
Yeah.
and have the vote not have to be a unanimous
Yeah.
vote.
I mean, yeah, that's something we've kicked about for a few years, and I think, it has to go back to the original. It has to be a pretty substantive, I think, vote to change the onus. I mean, something that they've talked about since I started doing this 6 years ago, and noted. Do we not have a motion from anybody?
Motion to continue.
About at least finding a violation.
I just made a motion to continue.
Just let me finish mine before you. About, the fact that, the documents were provided, but they're provided late. I mean, at least for the record. That's what Mr. Petrellis is here for tonight. If not, we have another motion on the floor. Is there a second to the motion to
Is there
continue?
a motion to continue on the floor? Is there a second?
So if there is no second,
It dies.
Matter dies with no violation.
I'll second it because that's my feeling. There's a violation.
There's a motion on the floor to continue the matter to a call of the chair for a future meeting. Is there any public comment on that?
Yes.
No.
Oh, yeah, remember you can't do that.
No, you testified.
Yeah, party.
In a month you can do that.
On the motion to continue the matter to a future date, Eldon absent. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher absent. Member Hinsey.
Aye.
Hinsey, aye. Chair Wolf absent. Vice Chair Highland.
Aye.
Highland, aye. The motion passes. The matter will be continued to a future date. The parties will be notified.
Well done.
Sorry.
I need clarification. What just happened?
They could not get a motion to find violation to the lack of
Right, that I
member.
understand.
And so, therefore, we continued it to our next meeting where we will hopefully have more members to consider your item and be able to take a new vote on the motion to
with
find
more
violation.
members. And Victor, he does not need to be here, does he, for that?
That is your decision and his decision to make.
Okay. I think we felt that, because we couldn't reach a decision with, even though you took your chances, we want to extend it to be able to vote more fully.
I believe the task force is waiving your appearance at the next meeting if you desire not to show up.
In October.
When this is rescheduled.
Whenever it's rescheduled.
Yes.
I'll probably be here. This is really important to me.
Right. Can I ask a question? Is he, an associate required to be there, or their appearance
I
waived?
believe at the committee meeting, he stated that he did not intend to attend the full task force meeting.
Well, he can state that he doesn't intend. The question is, will he be notified?
They are all notified of every meeting.
Okay.
Yeah. Yeah, at that meeting, he felt like, and we basically agreed with him that he gave enough information, and he said, okay, based on that, I'm not going to be there. I'm like, and we said, that's your choice, but you'll be notified, and he didn't show up, so I remember that correctly.
Okay. The matter has been continued.
Okay. Next item.
Next on the agenda, item number 12, Sunshine Ordinance Task Force Annual Report. I believe that we are still
A motion
working
to
on
continue.
drafting.
Yeah, let's do a motion to continue that. Is there a second?
Second.
Can we take that by acclamation? Is that something?
Public comment?
Okay. Public comment on the
Continuance.
of the annual report.
There being no public comment,
Wait, did we just
the motion is to continue.
The annual report. Yeah.
And could somebody? I was just notified that chairs of committees have to provide something. I have no idea.
Just a verbal. Just a verbal as to where. For the annual report.
I have provided a list. I have provided last year's copy to the members. That was quite a few months ago. I can read you that.
Yeah, please resend it.
And you can modify it as you see fit to state what you believe should go into the report.
Okay.
He's already included things. You can just add extra
Right.
things.
Okay. Let me just see the layout because I don't remember seeing it.
Yeah, basically it's just like, here's the cases we heard, and here are the three most important cases I think that we dealt with.
Okay.
It could just be as simple as that.
On the motion to continue, Eldon absent. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Fisher absent. Member Hinsey.
Aye.
Hinsey, aye. Chair Wolf absent. Vice Chair Highland.
Aye.
Highland, aye. The motion passes. Next on the agenda, item 13, report from the Sunshine Ordinance Task Force members.
And this is just to kind of...
Committee members, sorry.
Committee members, just to check in with the committee heads to see where we are on...
Is it the committee chairs?
The committee chairs.
Committee chairs, or if they're absent, other people on the
So-
may talk.
Compliance and amendments didn't have a meeting since our last meeting where I gave a little update, so I don't have anything.
Okay. What about complaints? Top of the list.
Same old, same old. We've been meeting every month. So.
Yes, and they have quite a large load.
Okay. All right.
But we are meeting every month. We have met
Yes.
every month, and so I don't know what to do.
Just as long as we're talking about that, in terms of scheduling for a complaint committee, I believe that there's a possible cancellation date of November 28th and a possible reschedule of November the 13th as an open date if you would like to use that. That's the Thanksgiving holiday week.
I mean, November 28th is a Tuesday, correct?
Yes, that's, I thought that was a Thursday.
We don't meet on Thursdays, though.
Yes, Tuesday, yes.
I'm available on that Tuesday. I guess I would have to hear from Member Hinsey if she's available on that Tuesday. I mean, I would prefer to meet if people are here.
Thanksgiving is on the 30th, is that right?
It's 2 days later.
On Thursday. I intend to be
Thanksgiving's on the 23rd.
I believe.
Oh, the week before.
Mm-hmm.
Okay. So Tuesday.
here. I
Okay.
really will be here.
Right, Victor?
Yes, I did list that. As Thanksgiving week is 23rd and 24th.
Yeah. So we would be meeting on the 28th, the Tuesday after.
I believe the consideration is to continue with the 28th and not to reschedule. Okay.
Okay. Thank you.
Thanks. Education, outreach, and training?
We had one meeting in this past month. It went well, but most of it was dealing with prepping for the interesting ethics case that we had at the beginning of the hour tonight. So that the only thing to report already got dealt with.
Okay.
Yeah.
I believe the Rules Committee will be meeting this coming September the 26th at 4 o'clock.
All right.
September 26th at 4 o'clock prior to the complaint committee. They do have some issues regarding the procedures and policies.
Yep.
And we would like to ask if any other committee members have any suggested changes. I can send everybody our list of issues to address at the moment. If you have anything else to add, it would be appreciated.
That's basically item 3, continuing, right? What we discussed
It's
today.
basically like continuing with things like the rule of reason, the precedence log, etc.
Okay.
Things of that nature.
Any procedural issues that
Yeah.
you would like us to change? I believe one of them is how does the task force file complaints against departments and issues like that.
Okay.
And it would be appreciated. I will send out a current copy of our list, and if you want to add anything, please send it in.
And just let us know where we are in that list. Like placeholder.
Mhm.
Okay.
Yeah.
Pretty good.
Information Technology Ad Hoc Committee, I don't have a pending meeting for them at this time.
Member Moss, any...
Sorry. Yeah, we haven't met. I don't think I'll be able to hold the committee until after the legislative session closes on September 15th, and then maybe we can schedule something after that.
Okay.
I'll work with Member Moss to decide future meeting dates and subjects.
Gotcha.
And the other thing for the Rules Committee is I believe we have to confirm our other membership. So we have to confirm our committee members.
I will send out a poll to make sure all the members for the Rules Committee will be able to attend. I don't have that list before me at this time. I believe
it's Highland and Fisher.
Yes.
Are we the other two?
I believe Vice Chair Highland is a member of the Rules Committee, and so is Member Fisher.
Okay.
I'll confirm with her to make sure she can attend.
And what time is that? 4?
That would be
4.
September the 26th at 4 o'clock.
Okay. Okay. All right. Next agenda. public comment on the reports?
I would like to, Ray Hart's Director, San Francisco Government, since this is on the task force committees, I would like to bring to your attention the fact that I think Chair Wolf is working under a real assumption that the complaint committee and others that are hearing complaints are supposed to kind of winnow things out and then come in here with a complete report. And, basically it seems to have gotten that you hear the complaints, but then you make no recommendation. You simply punt it to the full task force, and then when it comes to somebody giving a summary of what happened at the committee meeting, nobody says anything. They all just sit here, and it's kind of like, I'm the complainant. I work hard to do my case. I present the case, and then it's going to be put before the full task force by someone who doesn't even seem to have any interest at all in explaining exactly what the case was I presented. I mean, if you're gonna have these extensive hearings at the subcommittee level, the complaint committee and wherever you else decide to send it, well, then you ought to be able to take some notes and come in here and give a reasonable explanation to the full task force about what happened in those meetings. And I don't see that happening. Do you? Basically, what happens is somebody says, "Oh, this was heard in committee. Yeah, we sent it to you. Okay, does anybody want to explain it?" And everybody looks at everybody. And that's the end of the story. Now, like I said, I had some interaction with Chair Wolf, and he is under the assumption that that you're going to come and present to the full task force a pretty good summary of what happened in the respective committee. And instead, we're getting nothing. And one of the additional reasons I asked for my 3 complaints to be continued is because Chair Wolf heard all 3 of those, and he was not present tonight. And so I was questioning as to whether anybody would be able to give any information about those 3 complaints to the full task force. And without that, I think it's a denial of due process. I think if you're setting up a procedure which isn't working and it results in the person getting an unfair hearing, you have a real problem. And I think that's what I'm seeing happening. And I had the communication with Chair Wolf, and he said, no, we're all running it the same way, and we're all doing it the same way, and everybody understands exactly the way it's supposed to be done, but it is not obvious from looking from the outside in. And if anybody wants to, you have the right to respond to anything I say. And if you want to respond to it and say, no, Mr. Hartz, you're wrong, we're doing a really good job at summarizing these complaints that came up from our respective committees. I have yet to hear one that was even half-assed, excuse me. I mean, just basically people looking at each other and, you want to say anything? You want to say anything? I don't want to say anything.
I'll respond to that, Mr. Hartz. So, yes, there has been a change as to how the subcommittees are handling the initial, when they initially touch a case. And as you remember, a few years ago, we had the backlog. We were actually doing a lot of the actual adjudicating and whatnot at the subcommittee and recommending up to the full task force with recommendations of violations, having done a lot of legwork. Chair Wolf has decided that he doesn't like that. He wants the full task force to do the adjudication and the merits of the case. What he wants the subcommittee to do is basically unpack the case, make sure it's apples to apples. Now, in your case, a lot of your cases, you're more prepared than the average, petitioner. So that's probably not necessary.
We don't have quorum.
Oh. All right.
Back on the record.
Back on the record. So as I was saying, Mr. Hartz, we have had a fundamental change in how we treat cases at the subcommittee level. If they're not ready, we don't send them up. When they're ready, they get sent up, and then the merits get discussed and whatnot. I think Chair Tesfaye did a great job in summarizing her cases. Could we do better as a group? Quite probably. So your comments are well received. Thank you for that. And I'll communicate that to Chair Wolf as well. All right. Next item, which is item 14.
Item 14, Sunshine Ordinance Task Force Chair's Report. I do not have any items on the report today.
Okay.
I believe there is something for the next meeting, but that'll be just there.
All right. So do we just close that or continue that?
There's no action taken.
Okay. Next item.
Next item on agenda, item number 15, Administrative Support, Complaints, and Communications. In terms of the schedule, there's one under possible cancellation for a Compliance and Amendments Committee for November 21st. I do not know if you want to continue with that or postpone it or reschedule that. That is the Tuesday prior to Thanksgiving.
When would it be?
I think that would be a 4:30 meeting, but that is adjustable per.
Could people do the 14th instead? Is the second Tuesday available? Thanksgiving?
Actually, no. The possible rescheduling date would be the 13th. I believe it's Monday
of October.
No, November.
November.
I don't think I have anything on my calendar that far out, so I should be fine.
I'm okay with the 21st or the 13th.
Let's do the 13th then, because Thanksgiving week, people do leave. I don't know if I'm in town or not yet.
Okay.
But
So I believe we would like to reschedule the Compliance and Amendments Committee's November 21st meeting to be heard on the 13th instead.
4:30 still?
Yep.
Victor, is that a
Yes,
good time for here?
that'd be
Okay,
fine.
4:30 is fine then.
Okay.
The rest of my report, sorry. We have a listing of the new complaints issued this month. We now have a total of 40 complaints pending hearing. That's up slightly from last month. There are no issues pending in the committee level, which was referred to them from the task force, and that completes my report.
Just quick question on those.
Quick question, yeah.
On those complaints,
I think we
are
might
they
have the same question.
Are they coming from lots of different people, or is one person filing?
I have a listing of this last month. It's item number 2 on page 738 of who submitted the complaints.
Okay, thank you.
And then the 40 complaints that you had on your list there, Victor, that doesn't count all the continuances and
That does not count to. Actually, those include anything that's still pending a hearing before the task force or the committee. So it does include pending continued items.
And how
for
many?
tonight, or the ones that were continued?
Tonight's is still on the list.
Okay.
How many of those were filed since the last complaint committee meeting?
The ones listed on this is for the last month from 7:28 to 8:30. I don't have additional details besides that.
What was that number?
The ones listed on my report were submitted between July 28th and August the 30th.
Oh, no, I meant what is the number that were, how many were filed between the 28th and August 30th?
7, 9.
Thank you.
Okay. Next item, item 16.
Public comment on that?
Seeing
public.
no public in the room, there's no public comment.
Item 16, announcement, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Hello, can I, through the chair?
Yes, Member Moss.
Okay, so just some interesting updates for folks that may warrant hearings later or may not. My employers have won a significant lawsuit in the California Supreme Court over the data collected by license plate readers. The Supreme Court decided that the Los Angeles Police Department and the Los Angeles Sheriff's Department couldn't use the law enforcement exception to deny access to all of the license plate reader data they collect. It has been ordered back to the trial court or the district court level the Superior Court level to suss out how to release, what kind of data can be released, while still protecting people's privacy. So we may see a sort of ripple effect across the state with more requests related to license plate readers. San Francisco does have license plate readers, and so, just sort of putting it out there. This was a significant ruling limiting what the law enforcement exemption can cover. The two other things to sort of bring up is there were two important pieces of legislation that were acted on Friday of last week. SB 21 died in the Appropriations Committee by failing to come after it was off the Assembly Appropriations Committee, and it failed to make it off the suspense calendar, so it did not receive a vote. This would have been a bill requiring law enforcement transparency around the acquisition of surveillance technology. The other bill worth noting is AB 1479, which prior to Friday would have done two things. It would have required agencies to appoint or to designate a custodian of public records, and it also would have allowed requesters to receive a financial penalty, or sorry, it allowed courts to assign a penalty to agencies that willfully disregarded the California Public Records Act. For whatever reason, the legislature removed the penalty provision on Friday and have instead sent forth a bill that only requires agencies to appoint a custodian of public records. It's fairly weak sauce, in my opinion, but we'll see how it moves.
By any chance, do the author of that or the sponsor?
Bonta, Assemblymember Bonta. The only other future agenda item I would raise is based on the issues that we face tonight, that perhaps it is time to look at that a little bit more closely, and at the very least ask the chair to according to our bylaws, send a note about a member Copra. And because I have no idea what's going on with that, but I mean, after 3 meetings, the chair's supposed to send a letter. So
I hope he sends a letter. I heard that they are working on that. They've already filed many applications.
Letters. Yeah. However, the organization is pretty much non-operating.
Is it New American Media?
I believe that is.
Because I mentioned it to the league, and they said that New American Media says that they have someone who's up for confirmation. And I was like, I've never heard anything about that. And I meant to bring it up here to check, because I brought it. They were trying to do something with the league about Sunshine, and I was like, well, the person for their seat has never shown up, and they haven't replaced the person. And then they said, oh, well, do you have an application from someone from New American Media?
We don't even need. We just need an appointment letter.
Did they send anything?
From my understanding, we've been trying for many years now to get them to send us somebody new. The latest was that
look it up.
I believe that some other organization was going to provide suggestions to them so that they can appoint them. But as far as I know, they have not taken any actions.
And my understanding was that process of networking with the other organization ended up having some problems.
I wasn't aware of that. So.
And I did have a question, sorry, just before I get too far off topic. Does the vote demographic change if there's an open seat versus a seat that is filled by somebody who doesn't show up? So if we have...
No, it does not.
Okay.
Yeah, so I think regardless of having somebody appointed in place of Copra, we still need to take up the issue of what to do when we are understaffed. And is compliance and amendments the place to start that discussion?
I believe we can start at Rules Committee since they're considering those. And it is in our bylaws as to how we vote on certain items.
I think we should
How
add
do we
a
change our
charge.
bylaws?
Once it comes through the Rules Committee,
we just vote on it?
We can vote on it. I need to check to see if it's
Why haven't we done that in the past decade?
There's been some past issues over what constitutes a vote, and that's prior to member or Vice Chair Highland's
time,
where they were trying to do that, and there were some issues with it. I'm not familiar.
If Rick Nee was in the room, he could answer that. But they tackled it. I thought it had to go even further than that. I thought it had to
It did go quite far, and I'm not familiar.
Okay.
Does this relate to the Park Merced issue somehow?
No.
It was a matter of what constitutes a quorum for voting on a matter.
It might relate to when we were short an ADA member and therefore couldn't move forward. It might be going back to that time or even earlier. But I thought for some reason it ended sticking in my head that this had to be this level of charter change would have to be voted on, not by us but by the public. That's
anything changing. Chapter 67 must be voted on by the public.
I think that might be. And so the only way we could do it is we could encapsulate it with all the changes that we're trying to do, and then and there's an outside body.
But is this changing Chapter 67 or just our bylaws and how we vote?
We would need to check into that.
I think it's pretty substantial.
Because
Because the standard is a quorum of the body and not of the members present.
Yeah.
Does our city attorney have any opinion on that?
Any memory? Yeah.
So
Cheers.
I'm confused with the term quorum. We can't have a meeting if we have less than 6, right?
Actually, I should have said majority. In terms of voting, it would be the majority of the body itself.
And not the majority of the attendees.
Yes.
And that, to me, that is what we need to change.
Is that how all decisions are made across the city, or is it just us?
As far as I know, it's the majority of the...
Oh, so like that's how the charter has defined decision making is happening.
Right. And that's why sometimes you see planning commission meetings where certain commissioners absent themselves.
Yeah. And that's why there's strong language in the charter about if you miss more than 2, the letter has to go and all that stuff.
But whatever the case, I think it would just be cleaner for us to have on our agendas every meeting that there is an unfilled seat and not that there is a member who
missing.
I did ask about that, and I was informed that unless he resigns, I cannot list it as vacant.
No, but I mean, the Board of Supervisors can remove the members, is that not correct?
I've informed the Board of Supervisors of the issue many times over the years, and they have not taken any actions.
All right, well.
I'll... Okay.
That's all I got.
So, do we want to take this up in rules, or
I can put it on the list, and we can decide later.
Why don't
Let's
we
do that.
try to take it up in rules and try?
All right.
See what goes.
Next on the agenda is adjournment.
So moved.
Second. All right.